Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Introduction to Paralegalism, Perspectives, Problems, and Skills, 9th edition. Narrated by Omar Mohsen Ibrahim Fouad. Chapter 9. Legal Research. Chapter Introduction. Chapter Objectives. After completing this chapter, you should be able to distinguish between fact, research, and legal research. State the 4 categories of legal sites online and their reliability. Explain how to cartwheel a legal research problem. Distinguish the different kinds of legal authority. Summarize the hierarchy among primary authorities. Identify the major categories of secondary authority. Construct the citations for cases, constitutions, statutes, administrative regulations, and sources. Illustrate how to cite check a document. List major sources for finding and updating case law and statutory law. Compare and contrast the different features of Westlaw and LexisNexis. What if you have a client meeting on your calendar? The client apparently was charged with a DUI, driving under the influence. Based on the little bit of information the supervising attorney conveyed, it appears that the client was sleeping in the car and not driving when the police found him. From what you can tell, no breathalyzer test was given on site, and no other tests were given to determine the client's sobriety. This is all you know so far. However, your supervising attorney asks you to perform some preliminary research on the issue. Can you be charged with a DUI when you were not driving the vehicle? Can you be charged with DUI when the police did not observe you driving? How would the police prove that the client was driving under the influence when the client was sleeping and not driving? These are some of the questions that need answering, and you've been tasked with the assignment. As you head back to your office to begin your research, you contemplate your research plan, where to start, how to devise a plan when there are so many unanswered questions. These are some of the questions that will be answered in this chapter. Performing legal research is one of the most important skills that an attorney and paralegal need to master. In this chapter, we will examine where to begin a legal research assignment, the sources of law to apply to that research assignment, and the steps necessary to verify the status of the law relating to the assignment. Although seemingly daunting, learning the process and practicing these skills will make you more and more efficient and confident to address the tasks assigned. 9-1 Introduction. Many paralegals do fact research, in which they perform tasks such as finding the names of a company's board of directors or locating a report on whether conditions on the day a client had an accident. Fact research is covered in Chapter 13 on investigation. Here in this chapter, our focus is legal research, which consists of finding law in a traditional or online library to help resolve a legal issue. If asked whether they do legal research, a few experienced paralegals will answer all the time. For most paralegals, however, the answers will be either no or occasionally. An attorney might ask a paralegal to bring me statute 120 from the state code, find the statute that allows us to request an extension of time to file an answer, check the website of the Secretary of State for the forms to file when a business wants to incorporate. Go online and get me a copy of every case cited in the motion of an opponent. Cite check an appellate brief. Cite checking involves making sure all the citations are in proper citation form, all quotations are accurate, etc. Go on Pacer and find me the Foley complaint. Pacer is the online system of obtaining case and docket information on cases filed in federal courts. In most law offices, however, broader research questions are performed by attorneys. Examples: has the employer committed age discrimination? Is the city liable for injuries to patrons injured in a public park? Nevertheless, paralegals should have a comprehensive understanding of legal research. First of all, like most legal skills, you won't know if you'll use them until you find out what your particular supervisor will ask you to do. More importantly, the study of legal research exposes you to numerous dimensions of our legal system. Legal research gives you experience and interaction with primary sources such as court opinions, statutes, regulations, and constitutions, directly or indirectly. Each of these sources is often a product of delicate and hard-fought policy deliberations in our major government institutions. Furthermore, legal research is closely interconnected with the skills of legal analysis and writing. An excellent way to understand the heart of the practice of law is to listen and watch attorneys talk and write about cases, statutes, and other primary authorities, all of which begin on the websites of legal databases or, now, in the rarer occasion, in the library itself. No matter where the process begins, it is an important component of your legal education and a skill that needs to be developed to assist any legal professional in the development of a client's case and determining the basic rules that may apply to a set of facts. So, will you be doing extensive legal research on the job? Possibly, as it will depend on your job responsibilities, should you nevertheless become skilled in the techniques of legal research? Definitely yes. This chapter does not cover every aspect of legal research, nor does it treat every conceivable legal resource that could be used. Rather, the chapter examines the major components of legal research with the objective of identifying effective starting points. When you start a search online, or on the occasion when you may walk into a law library, your first impression is likely to be a bit overwhelmed, or one of awe when confronted with row upon row of books in a library. Neither invite casual browsing. The amount of law that is available online and in a law library seems staggering. but, as you will learn, is manageable. This chapter will teach you to handle this quantity of material so that you are able to use whatever source is available, whether brick and mortar or online law libraries. You need to learn the techniques of legal research and understand its limitations. A major misunderstanding about learning and researching the law is that there is always an answer to every legal question. Often, legal questions have no definitive answers because the courts have not addressed the question or because they have given us inconsistent answers. Although a client is entitled to an answer, to clear guidance, this may not always be the case. Think of some of the significant issues addressed by the U.S. Supreme Court. What appears to be the law or not on one day may change with the issuance of a case opinion or the passage of a statute. Therefore, part of the attorney's job is to identify alternatives or options and to weigh the benefits and disadvantages of each option to the best of their ability based on the current state of the law. Good attorneys are so inclined because they understand that our legal system teems with unknowns and ambiguities. Good paralegals also have this understanding. Not all legal research problems fall into this category. Indeed, many problems can be answered by basic legal research. Suppose, for example, you want to know the name of the state government agency in charge of incorporating a business or the maximum number of weeks one can receive unemployment compensation. Finding the answer is not difficult if you know what resources to go to and how to use their indexes or other points of access. In school, you will learn a good deal of law. Eventually, you will probably forget most of it. No one can know all of the law, even in a specialty. Furthermore, the law is always changing. In just a year, tens of thousands of statutes and administrative regulations are passed, and just as many court opinions are written by the three branches of government. Consequently, a law office cannot practice on the basis of rules learned in school. Those rules may no longer be valid by the time you try to use them in actual cases. Thousands of courts, legislatures, and administrative agencies spend considerable time writing new laws and changing, interpreting, or adapting old ones. In light of this reality, you need to focus on the techniques of doing legal research covered in this chapter. These techniques will remind you to distrust the law you think you know and will equip you to find out what the law is today. Legal research may be a challenge for you at the beginning, but with experience and the right attitude, you will overcome the difficulties. The most important advice is stick with it. Spend a lot of time in the library, physical and online. Be inquisitive. Ask questions of fellow students, teachers, librarians, attorneys, paralegals, legal secretaries, etc. Be constantly on the alert for tips and techniques. Do not wait to be taught how to use sets of books that are new to you. Strike out on your own. Do the same online. Visit research sites often. Take advantage of links to click your way around sites you are on and sites to which you are led. We will be saying a good deal about computers in this chapter and in chapter 11. Computers can be very helpful, but they do not eliminate the need to learn book basics. Keep this caution in mind. The computer will become your best friend only when you have acquired the techniques of traditional book, i.e., important example, paper, legal research that will allow you to find what you need without a computer. Intelligent use of computers requires an understanding of the fundamental techniques of legal research. Furthermore, computer legal research can be expensive. A good deal of free legal information is now available online. But as we will see, it is not always as current, accurate, or user-friendly as information available in traditional library volumes and in commercial fee-based computer research services. At this stage of your career, most of the frustration will center on the question of how to begin your legal research of a topic. Once you overcome this frustration, the concern will then become how to end your legal research. After locating relevant material, you will worry about when to stop. In this chapter, our major focus will be the techniques of beginning. Techniques of stopping are more troublesome for the conscientious researcher. It is not always easy to determine whether you have found everything that you should find. Although guidelines do exist and will be examined in the chapter, a great deal of experience with legal research is required before you can make the judgment that you have found everything available on a given topic. The techniques you need will come with time and practice. Don't be too hard on yourself. You will not learn everything now. You can only begin the learning that must continue throughout your career. There are no easy roads to learning legal research. It is often simply that the more assignments you research, the better you get at the skill. There are definite pathways to learning and mastering legal research. Once learned, the journey can be an interesting one, especially when you experience the satisfaction of a job well done. As we work through this chapter, you will learn new skills and new terminology. That is simply part of the journey, but we will begin with where to start: online and traditional libraries. 9-2 Performing legal research online or the traditional law library. That is the question. Legal research can be performed either online or in a traditional law library. The never-ending debate is which is better, more efficient, and more comprehensive. We will not answer that question here. But what we will say is that both are skills that should be mastered. Most offices lean toward online libraries, but also may have hard-bound copies of their jurisdiction's statutes and cases for quick reference. Sometimes it is easier to grab a book off of the shelf rather than search online for a statute, and sometimes the books may have more current versions of the law as some online sources lag with updates. Regardless, knowing how to navigate both online and traditional libraries is important. What if you are in court with an attorney on a case and you need to find the text of a statute but do not have internet access? Knowing how to locate the statute in a book is important. Consequently, as we journey through all the different sources of the law, keep in mind that you need to be able to use both online and traditional legal resources and understand how both work. We will start with online research. 9-2A Online Legal Research. A general overview. As indicated, there is a tremendous amount of law online. Indeed, some law offices canceled many of their subscriptions to paper publications once they realized what they could obtain from fee-based and free law sites online. There are 3 kinds of legal materials in a brick and mortar library and in online legal databases. Primary authority: any law, constitutions, statutes, opinions, court rules, administrative regulations, administrative decisions, executive orders, ordinances, charters, and treaties. Secondary authority: any non-law that summarizes, describes, or explains the law. Examples: legal periodicals, legal treatises, and legal encyclopedias. For definitions, see later sections in the chapter. Finding and updating resources. These are tools that allow you to locate, find primary and secondary authority. The tools also allow you to update primary authority by telling you if the primary authority you have found is current or has been changed in any way. Examples of finding and updating resources include digests, Shepard's citations, and KeyCite. These examples will be defined later in the chapter. Secondary authority can also help you find primary authority, as we will see. Our main concern here is primary authority that you find online. How reliable is it? 9-2B Reliability of law online. There are 3 main categories of legal sites online. Fee-based private sites, free government-run sites, and free private sites. Fee-based private sites. There are 2 groups of fee-based sites based on cost. The 3 giants in online legal research sites are Westlaw, Westlaw Precision, or Westlaw Next. www.westlaw.com. LexisNexis, LexisAdvance, www.advance.lexis.com or www.lexis.com. Bloomberg Law, www.bloomberglaw.com. Other fee-based online legal research sites are FastCase, www.fastcase.com. CaseMaker, CaseMakerX.com. Quick tip: most state bar associations and some local bars give their members free access as a membership benefit to legal research databases. Paralegals may be able to sign in under authorization of their supervisors who are members of that bar. These fee-based private sites are highly reliable for obtaining the full text of primary authority. They employ an army of attorneys and other staff to ensure that the material on them is current and that special finding features are added to enhance the user-friendly experience of their paying customers. These sites also contain secondary authority as well as finding and updating resources. Free government-run sites. Almost every federal, state, and local government body has a website that contains the full text of all or most of the primary authority it writes. These sites are maintained by legislatures, courts, the chief executive, and administrative agencies. These sites are also very reliable, and they are quite popular. A high percentage of attorneys rely on the law they find on them. These sites, however, are generally not as user-friendly and comprehensive as the fee-based sites. Occasionally, a government site will caution the user that the law on the site may not be current. One state, Kentucky, has a more ominous warning. The files making up this internet version of the Kentucky Revised Statutes do not constitute official text of the statutes and are intended for informational purposes only. No representation is made as to the accuracy or completeness of these acts. No representation is made as to the accuracy or completeness of these sections. Hence, caution is needed when relying on the law found on government sites. Updating steps must be taken, as we will see. In order to improve public confidence in the government sites, some states have passed the Uniform Electronic Legal Material Act, UELMA, to provide a method of letting users know that the law contained on the government site is authentic. The method can consist of placing the law on a secure website or using a special electronic symbol, a digital thumbprint of some kind, to indicate authenticity. If electronic legal material is authenticated, it is presumed to be an accurate copy of the legal material. It should be noted, however, that law offices continue to flock to government sites to obtain the text of primary authority, even in states that have not enacted the UELMA. Online exercise. Determine whether your state passed the Uniform Electronic Legal Material UELMA Act. If so, when was it passed? Many of the free government sites also give summaries and interpretations of primary authority. These summaries and interpretations are modern examples of secondary authority. Free private sites. Finally, there is a great variety of free private sites online. Sites will have their own databases containing the full text of primary authority. A major example is Google Scholar, scholar.google.com, for court opinions. Sites containing numerous links to government sites that provide the full text of primary authority. Sites of law offices, associations, foundations, businesses, and individuals that contains summaries and interpretations of those primary authorities that pertain to their areas of interest or expertise. With one exception, there are no absolute guidelines to determine the reliability of what you find on free private sites. Although sites such as Google Scholar and the links to the government sites have good reputations, caution is the order of the day. The exception concerns the summaries and interpretations of primary authority that appear to saturate the internet. Never rely on them as substitutes for the primary authorities themselves. The summaries and interpretations may be valuable if they contain references or links to primary authority. Follow the references and links, but never take the risk that the summaries or interpretations of primary authority are accurate or current. You must rely on the text of the primary authority and not solely on what a law firm, association, foundation, business, or individual says about the primary authority. Think of it as the commentary or opinions of the author. They are interpreting what they believe the primary source says or represents. Consequently, go to a source that has the original form of the document. 9-2C, Wikipedia. Perhaps the largest free private website that summarizes and interprets legal and non-legal topics is Wikipedia. www.wikipedia.com. You need to be cautious about the content of legal materials on Wikipedia, not simply because the site allows users to make corrections and additions to its millions of entries, but mainly because the site does not contain the full text of reliable and current primary authority. Attorneys or paralegals would look foolish if, for example, they cited Wikipedia as their only source for the law of collective bargaining. Researchers need to rely on and cite collective bargaining statutes, cases, and regulations. The primary authorities. Yet, free private sites such as Wikipedia can be quite valuable to a legal researcher. They will often provide references and links to primary authority. Furthermore, you need to do background research on a topic, they can be quite useful. 9-2D, Google, a good place to begin. Of course, you should have no hesitation in using general search engines to find legal materials. Many attorneys frequently start with a Google search, especially for general background research on a topic. The major search engine competitors to Google, Bing, and Yahoo are also excellent starting points. Suppose, for example, you are working in a law office where the client is Jane Richards, a 5-year-old passenger in a Ford Taurus who was injured when the airbag in the car activated on its own without a collision or other impact. Here are some possible searches to try in Google, Bing, or Yahoo. Airbag injury, injury defective airbag, airbag self-activation, Ford Taurus airbag defect, child injury airbag activation. Add the name of your state to each of these queries. To narrow the search further, the goal of such searches is to lead you to relevant primary authority and, for background research, to summaries and interpretations of such primary authority. 9-2E, Google Scholar. It's not too early to become familiar with the valuable resource called Google Scholar. Scholar.google.com. On its homepage, you can select case law to obtain access to the full text of court opinions, articles to obtain articles on a large variety of legal and non-legal topics. To read some of the articles, you must pay a fee, although there are links to numerous free articles as well. Online exercise. To learn more about Google Scholar, search in Google, Bing, or Yahoo how to use Google Scholar. Outline the information provided and place in your portfolio binder. 9-2F, additional sources for finding law online. Online sources for finding the law change all the time, and keep up with those changes keeping up with those changes are nearly impossible. However, some sites, such as law school libraries, provide access to most primary sources for free. Some free sources are law school libraries, Cornell University Law School, www.guides.library.cornell.edu/online legal resources, Harvard University Law School, guides.library.harvard.edu, University of Michigan Law School, www.michigan.law.umich.edu/law library. Statutes and cases, federal. 1. www.michigan.law.umich.edu www.congress.gov. 2. www.usa.gov. 3. www.supremecourt.gov. 4. www.uscourts.gov. Executive branch documents. 1. www.whitehouse.gov. 2. www.archives.gov. State case and legislative information. 1. www.ncsl.org. 2. ncsc.org. General websites: findlaw.com. 2. justia.com. 9-3. Finding traditional law libraries. 9-3A. Traditional law libraries. Assume that you want to use a traditional law library, a brick and mortar facility where you can hold books in your hand. What are your options? There may be such a library in the office where you work, although, as mentioned, many offices have canceled their subscriptions to some paper publications, relying instead on free and fee-based material online. The availability of traditional law libraries outside your office depends to a large degree on the area where you live, study, or work. Rural areas, for example, have fewer possibilities than larger cities or capitals. Online exercise. Search for area law libraries by using a search engine and enter your state, city, or town, followed by law library. Examples: Dallas, Texas, Law Library; Boston, Massachusetts, Law Library; Albany, New York, Law Library. Look for libraries that are run or funded by the government. Check their websites to determine whether the public can use them. In general, court law libraries will not allow public access, whereas the state law library and county law libraries, if any, will allow such access. If unsure, call the library and ask. College and university libraries are often restricted to their own students unless they are depository libraries. See the next section. 9-3B. Depository libraries. A federal depository library is a public or private library that receives free federal government publications to which it must allow access by the general public. The publications include federal statutes, federal regulations, and federal court opinions. If the library is private, like for example a private university library, the public right of free access may be limited to those publications the library receives from the federal government under the Federal Depository Program. The private library has the right to prevent the public from using the rest of its collection. The Federal Depository Library Program, FDLP, gives you access to federal laws. Some states have comparable state depository library programs for state laws. To find both kinds of depository libraries, see Exhibit 9-1. Some libraries are both federal and state depository libraries. Exhibit 9-1. Depository libraries. Federal depository libraries. Go to gpo.gov. Alternatively, enter this search in Google, Bing, or Yahoo. Federal Depository Library. On the site, find the links on locating a federal depository library. Click your state. Click the link to the library closest to you or do a search in Google, Bing, or Yahoo for the name of that library. On the site, look for information on gaining access to the print collections that are part of the Federal Depository Library. Some libraries discourage use of their facilities by directing you to the online sites of federal laws. If, however, you want to use the paper volumes, the library must give you access to them. State depository libraries. To find out if there is a state depository library in your state that contains state laws, perform this search in Google, Bing, or Yahoo. AA Depository Law Library, substituting the name of your state for AA. Every state has a central state law library. Go to the state of this library by searching AA State Law Library. Substitute the name of your state for AA. If your state has a state depository library for state laws, the above searches should lead you to information about how it works and how to find state depository libraries nearest you. 9-3C. Your neighborhood public library. Surprisingly, non-libraries often have legal materials on their shelves, like, for example, the current state statutory code. In the card or online catalog of your neighborhood or central public library, find out 1. What legal materials it has on its shelves, and 2. How current, up to date, any particular legal material is. Some of these libraries have very little legal material, and what they have may not be up to date. Nevertheless, it is worth checking what is available. 9-4. Ask an online librarian. Before we leave the topic of law libraries, you should know about a frequently overlooked resource that is available to you. Ask a librarian. Programs exist throughout the country. The Library of Congress, for example, has an Ask program that provides legal and legislative research assistance for federal and state law. ask.loc.gov. Most Ask programs are available by email to help answer questions about where to find legal information, like, for example, statutes on divorce and factual information, reports on airline crashes. The programs cannot give legal advice, but they can provide useful leads. You can ask general questions, like, for example, where can I find the regulations of the Environmental Protection Agency? And specific questions, like, for example, how can I find out how to appeal a Missouri workers' compensation decision? The Ask programs are sometimes limited to designated populations, such as the students of particular universities. The website of the program will list any restrictions that exist. Don't be reluctant to contact Ask programs located outside your state. Many are eager to help, no matter where the inquirer is located. Furthermore, the Ask program does not have to be located within a law library. Good leads can come from any skilled reference librarian to whom your question will be directed. 9-5 Cartwheel. What search terms should you try in a search engine or in the index to a book? This is not always an easy question to answer once you find out that your first few attempts with the search engine or index have not been successful in leading you to what you need. When this occurs, try the cartwheel, which is a technique designed to help you think of a large variety of words and phrases to check in search engines and indexes. Here is what a veteran teacher of legal research, Professor Roy Steele, says about using this technique. I think it is important for students to understand that they cannot just walk into a library and start pulling books off of the shelf. That is the quickest way to become frustrated. Legal research requires thoughtful planning. A student must determine which resources will be checked. It is not enough that a student knows that a certain resource has an index or table of contents. The student must know what they are looking for. This requires the student to develop a list of search terms. Some people would call the development of this list brainstorming. However, brainstorming is somewhat hit or miss. It lacks structure and organization. The cartwheel is one of the most effective ways of systemically developing a list of search terms. It is a method of analyzing a legal problem and developing a list of descriptive words, which can be used to search indexes. Professor Steele's comment applies to search engines as well. The objective of the cartwheel can be simply stated: to help you develop the habit of phrasing every word involved in the client's problem in multiple ways. When you go to a search engine or book index, you naturally begin looking up the words and phrases that you think should lead you to relevant material. If you do not find anything on point, two conclusions are possible. There is nothing on point in the book or online. You checked the wrong words in the index or search box. Too often, we make the mistake of thinking that the first conclusion is accurate. 9 times out of 10, the second conclusion is more accurate. The solution is to be able to phrase a word in as many different ways and in as many different contexts as possible. Hence, the cartwheel. See Exhibit 9-2. The cartwheel generating search terms for indexes and search engines. Wedding. Broader words, closely related words, synonyms, related terms of procedure and remedy, narrower words, long shots, antonyms, courts and agencies. Identify all the major words from the facts of the client's problem or the assignment, like for example, wedding. One at a time, place each word or small set of related words in the center of the cartwheel. Look up all these words in the index of law books or type them into a search engine. Identify the broader categories of the major words. Look up all of these broader words in the index of law books or type them into a search engine. Identify the narrower categories of the major words. Look up all these narrower words in the index of law books or type them into a search engine. Identify all synonyms of the major words. Look up all of these synonyms in the index of law books or type them into a search engine. Identify all of the antonyms, words that mean the opposite, of the major words. Look up all of these antonyms in the index of law books or type them into a search engine. Identify all words that are closely related to the major words. Look up all of these closely related words in the index of law books or type them into a search engine. Identify all terms of procedure and remedy related to the major words. Look up all of these procedures and remedy terms in the index of law books or type them into a search engine. Identify all courts and agencies, if any, that might have some connection to the major words. Look up all of these courts and agencies in the index of law books or type them into a search engine. Identify all long shots. Look up all of these long shots in the index of law books or type them into a search engine. Note, the above categories are not mutually exclusive. Let's look at an example. A bride and a caterer have a dispute involving food that was ordered. Assume that one of the major words in the dispute is the word wedding. Place this word in the center of the cartwheel. It will be the first word that will be cartwheeled. Look up the word wedding in the index of every law book you are checking. Type the word in the search box of Google or whatever search engine you are using. If you are not successful with this word, it may be because 1. The word is not in the index. 2. The page or section references after the word in the index do not lead you to relevant material in the body of the book. Or 3. The sites the search engine led you to are equally unproductive. The next step is to think of as many different phrasings and contexts of the word wedding as possible. This is where the steps of the cartwheel can be useful. If you apply these steps of the cartwheel to the word wedding, here are some of the words and phrases that should come to mind. 1. Broader words: celebration, ceremony, custom, festivity, formality, matrimony, observance, rite, ritual, sacrament, service, etc. 2. Narrower words: church wedding, civil wedding, double wedding, formal wedding, golden wedding, group wedding, informal wedding, military wedding, proxy wedding, religious wedding, same-sex wedding, sham wedding, shotgun marriage, Vegas wedding, etc. 3. Synonyms: spouse, join in wedlock, jump the broom, marriage ceremony, nuptial, tie the knot, etc. 4. Antonyms: alienation, annulment, breakup, divorce, legal separation, separation, split up, etc. 5. Closely related words: anniversary, betrothal, blood test, bride, children, cohabitation, community property, conjugal, connubial, consummation, contract, domestic, domicile, family, home, husband, license, marital, marital relations, matrimony, minister, monogamy, name change, partner, premarital, relationship, residence, sexual relations, spousal, spouse, vows, wedlock, wife, etc. 6. Procedure and remedy terms: action, breach of contract, complaint, court case, defense, discovery, jurisdiction, lawsuit, legal proceedings, legal process, petition, process, statute of limitations, suit, trial, etc. 7. Courts and agencies: Bureau of Vital Statistics, county clerk, county court, court, Department of Social Services, enforcement, family court, justice of peace, juvenile court, license bureau, office of child support, superior court, Supreme Court, etc. 8. Long shots, alimony, antenuptial, bigamy, chastity, common law, consent, custody, dowry, fraud, gifts, illegitimate, impotence, incest, paternity, pregnancy, property division, relationship, religion, remarriage, separate maintenance, single, blood, support, virginity, etc. If the cartwheel can generate this many words and phrases from a starting point of just one word, wedding, potentially hundreds more can be generated when you subject all of the important words from the client's case or assignment to the cartwheel. Do you check all of these words in the index volume of every law book or type them all in search engines? No. You cannot spend your entire legal career working on one case or one assignment. Common sense will tell you when you are on the right track and when you are needlessly duplicating your efforts. You may get lucky and find what you are after in a few minutes. For important tasks in any line of work or play, however, being comprehensive is often time-consuming. The categories in the cartwheel will overlap. They are not mutually exclusive. Also, it is not significant whether you place a word in one category or another, as long as the word comes to your mind. The cartwheel is, in effect, a word association game that should become second nature to you with practice. Perhaps some of the word selections in the wedding example seem a bit far-fetched. You will not know for sure, however, whether a word will be fruitful until you try it. Be imaginative and take some risks. Example of legal thesaurus. You do not need a thesaurus to generate words from the cartwheel, but you may find one to be helpful. Most software programs, such as Word and WordPerfect, have a built-in thesaurus that is easy to use. In addition, you can use a standard thesaurus such as West's Legal Thesaurus Dictionary, Ballantyne's Legal Dictionary, and Thesaurus, or Roget's International Thesaurus. 9-5A Other Index Search Systems. 9-5A The cartwheel is not only the technique for using indexes and search boxes effectively. Others include descriptive words and TAPP. Descriptive words. The publisher Thomas Reuters suggests a 5-part descriptive word framework for generating search terms. Parties, places or things, bases of action or issue, defenses, relief sought. By trying to identify terms that fall into these categories, you will be generating numerous words to check in indexes and search engines. Parties. Identify persons of a particular class, occupation, or relation involved in the problem you are researching, like, for example, commercial landlords, children born out of wedlock, physicians, sheriffs, foreign nationals, or collectors. Include any person who is directly or indirectly necessary to a proper resolution of the legal problem. Places or things. Identify all significant objects, namely the places and things perceptible to the senses that are involved in the research problem, like, for example, automobiles, sidewalks, derricks, garages, or office buildings. An object is significant if it is relevant to the cause of action or dispute that has arisen. Basis of action or issue. Identify the alleged wrong or infraction, like, for example, negligence, loss of goods, assault, failure to pay overtime, or sex discrimination. Defenses. Identify reasons in law or fact why they are arguably should be no recovery. Identify reasons in law or fact why there arguably should be no recovery. Like, for example, assumption of the risk, failure of consideration, act of God, or infancy. Relief sought. Identify the legal remedy being sought. Like, for example, damages, injunction, or annulment. Example. At a professional wrestling match, the referee was thrown from the ring in such a way that he struck and injured the plaintiff, who was a front row spectator. The following descriptive words for this problem should be checked. Parties: spectator, patron, arena owner, wrestler, referee, promoter, pugilist, ticket holder, etc. Places and things: wrestling match, amusement place, theater, show, playhouse, hall, arena, etc. Basis of action or issue: negligence, injury, personal injury to spectator, liability, carelessness, recklessness, due care, lack of, etc. Defense: assumption of risk, contributory negligence, comparative negligence, etc. Relief sought, damages, compensation, recompense, etc. 9-5B. TAPP. Another system of generating search terms is to think of TAPP categories: things, acts, persons, or places involved in the problem you are searching. Things: automobile, pool, knife, blood, etc. Acts: swimming, driving, rescue, accounting, etc. Persons: mother, pedestrian, driver, etc. Places: state, freeway, residence, etc. A variation is a TARPP, in which an R category is added to prompt you to think of relief or remedy words to check. Relief and remedy: suit, damages, litigation, injunction, specific performance, etc. A further variation is TARP. Things, like, for example, circus, dog bite. Actions, like, for example, breach of contract. Relief, like, for example, damages, injunction. And persons or parties, like, for example, spouse, employer. Let's use our facts from the beginning of the chapter to start a research plan using descriptive words. Parties: driver, passenger, police officer, law enforcement. Places or things: parking lot, parked vehicle in the street, parked vehicle not in the public road or public way, basis of action or issue, not guilty of DUI because not driving, not guilty of DUI as vehicle parked and no one driving, no test performed at the site of DUI, no proof of intoxication, vehicle not in public road or public way, no criminal responsibility for DUI, no legal stop by law enforcement, no probable cause to stop or investigate sleeping driver for DUI. Defenses: not driving car, stationary vehicle, parked automobile, parked car, sleeping car driver, no criminal liability. Relief sought: acquittal, not guilty, not liable, no responsibility. Suppression of evidence of DUI. This is a start to our research plan, as we do not know specific facts that apply to the client's case. Preliminary research may indicate some of the questions that should be posed to the client, such as the state of law when a law enforcement officer can investigate a sleeping passenger for a DUI. What facts must be present for DUI when a person is not driving the vehicle? Now that we have a starting point for making our research inquiry, we now must determine what kind of legal authority may apply to the facts of a case presented for research. 9-6 Kinds of authority. Legal research is a search for authority, which is anything written that could be relied upon in making a decision. Our overview of authority will cover the following themes: the two major categories of authority: primary authority, any law, and secondary authority, any non-law. Primary authority, which can be either mandatory authority or persuasive authority. The hierarchy among primary authorities. Secondary authority, which can be persuasive authority. 9-6A Primary authority. As we have seen, primary authority is any law written by one of the three branches of government. For example, the judicial branch writes opinions, the legislative branch writes statutes, and the executive branch writes administrative regulations. There are two kinds of primary authority: mandatory and persuasive. Mandatory authority. Mandatory authority is primary authority that is binding. It must be followed. The court must rely on and apply mandatory authority in reaching its decision. To understand this principle, we need to examine three questions. When is state law mandatory? When is federal law mandatory? And what law is mandatory when state law conflicts with federal law? State constitutions. The provisions of the state constitution are mandatory authority in that state. For example, the provision in the Idaho Constitution on the right to a jury trial is mandatory authority in Idaho. State statutes. The statutes of the state legislature are mandatory authority in that state. For example, an Illinois statute on divorce is mandatory authority in Illinois. State court opinions. The holdings of the opinions of the highest state court in the state are mandatory authority in that state. All lower state courts in the state must follow those holdings. For example, the holding of an opinion of the California Supreme Court on eminent domain is mandatory authority in every lower state court in California, such as in one of California's superior trial courts. State administrative regulations. The administrative regulations of state administrative agencies are mandatory authority in the state. For example, a regulation of Arkansas's Workers' Compensation Commission on filing a claim is mandatory authority in Arkansas. Federal Constitution. The provisions of the U.S. Constitution are mandatory authority throughout the country for any power that this Constitution gives to the federal government. For example, the provision in the U.S. Constitution gives the U.S. federal government the power to print money is mandatory authority everywhere. New Jersey could not create its own currency. Federal statutes. The statutes of Congress are mandatory authority throughout the country if statutes are carrying out a power granted to Congress by the U.S. Constitution. For example, a statute of Congress that regulates interstate commerce is mandatory authority because the U.S. Constitution gives Congress the power to regulate interstate commerce. Federal administrative regulations. The administrative regulations of federal agencies are mandatory authority throughout the country if the regulations are carrying out a power properly delegated to the agency by Congress. For example, a regulation of the Social Security Administration on eligibility for Social Security is mandatory authority throughout the country because the regulation is carrying out the Social Security Act, a statute of Congress. Federal court opinions. The holdings of the opinions of the highest federal court, the U.S. Supreme Court, are mandatory authority for all lower federal courts in the country. They are also mandatory authority for all state courts in the country, but not only if the holdings are interpreting the U.S. Constitution or some other federal law based on this Constitution. For example, a holding of the U.S. Supreme Court that the Equal Protection Clause of the U.S. Constitution prohibits race discrimination in voting is mandatory authority in every federal court and in every state court. On the other hand, if a holding of an opinion of the U.S. Supreme Court is interpreting the meaning of a clause in the Iowa Constitution, a state law, the holding would not be mandatory authority on any state court in Iowa. Iowa courts have the final say on the meaning of Iowa law and on whether anyone has violated Iowa law. Conflict between federal and state law. Federal courts are the final authority of the meaning of federal law. A state court is the final authority on the meaning of its state law. If, however, state law conflicts with federal law, the controlling mandatory authority is federal law. The result is based on the supremacy clause of the U.S. Constitution. Example of conflict. A New York statute, Statute 102, says that alimony can be granted to divorcing spouses in need. An opinion of the highest state court in New York holds that Statute 102 applies to needy ex-wives, but not to needy ex-husbands. This holding is mandatory authority in all lower state courts in New York. New York courts have the final say on the meaning of New York state law. A federal court, however, can rule that a state statute that grants alimony to needy ex-wives, but not to needy ex-husbands, violates the Equal Protection Clause of the U.S. Constitution. Under the Supremacy Clause, federal courts have the final say on whether a state law violates federal law. This is quite different from the question of what a state law means. State courts decide this question. Federal courts, however, can decide the question of whether a state law violates federal law. Analyze this. Locate a copy of Allen v. Milligan, 599 U.S. 143S CT 2607 216L ED 2D 1207 2023, and determine the main issue presented to the U.S. Supreme Court. Did the case involve a federal or state statute? What was the court's holding in the case? Research the history of the case and how the state of Alabama responded to the Supreme Court's ruling. Analyze this. A state law states that only men can commit domestic violence and punishes only men for the offense. Quincy Fitzwilliam sues the state, stating that the law is unconstitutional as it violates equal protection. The highest court in the state finds the law constitutional. Quincy appeals to the U.S. Supreme Court. The U.S. Supreme Court overturns the state decision. Must the state follow the decision of the court? If the U.S. Supreme Court has not ruled, must another state follow the other state's precedent? Defend your response. Persuasive authority. Persuasive authority is any primary authority or secondary authority that is not binding, but that could be relied on by a court because it finds the authority helpful, persuasive, in reaching its decision. Persuasive authority is any primary authority or secondary authority that is not binding, but that could be relied on by a court because it finds the authority helpful, persuasive, in reaching its decision. When we covered mandatory authority earlier, one of the examples presented was the holding in the opinion of the California Supreme Court on eminent domain, which we said is mandatory authority in every lower state court in California, such as one of its superior courts. This holding would not be mandatory authority in the state courts of any other state. Suppose, however, that a Florida state court likes the reasoning used by the California Supreme Court when it reached its eminent domain holding. If the Florida court decides to follow the California opinion, the latter will become persuasive authority for the Florida court. 9-6B. Hierarchy among primary authorities. Before leaving the topic of primary authority, we should say a word about the hierarchy of laws among primary authorities. The following principles apply. The highest authority is the Constitution, which is the fundamental law that creates the branches of government, allocates power among them, and defines some basic rights of individuals. Statutes, court opinions, rules of court, administrative regulations, and all other primary authorities must be consistent with the Constitution. The Constitution is higher in authority than these other primary authorities. Administrative regulations, must be consistent with statutes. Statutes are higher in authority than regulations. Common law is judge-made law in the absence of controlling statutory law or other higher law. Statutes are higher in authority than common law. The legislature can pass a statute that changes the common law. Such statutes are said to be in derogation of the common law. 9-6C, Secondary Authority. Secondary authority is any non-law that summarizes, describes, or explains the law, but is not a law itself. The major examples of secondary authorities are legal encyclopedias, legal periodicals, legal treatises, practice guides, loose leaf services, and legal dictionaries. Opinions of the Attorney General are a special category of secondary authority. Let's briefly examine each category of the major secondary sources of authority. Legal encyclopedias. A legal encyclopedia is a multi-volume, multi-titled compilation of the law. It is like what we know as a general encyclopedia, such as Britannica, but devoted to legal subjects. The main two legal encyclopedias are Corpus Juris Secundum, known as CJS, and American Jurisprudence 2D, known as AmJur. The encyclopedias can be found online on fee-based sites such as Westlaw and LexisNexis, or in written hard-bound volumes in most law school or legal libraries. Legal encyclopedias assist with providing general information about a legal topic and include reference to cases, statutes, and the Constitution where applicable. They are considered a finding tool and are a good place to start any legal research project. Many states have state-specific encyclopedias which provide state-specific commentary on legal topics. The references in a state-specific encyclopedia will be limited to that state's law and cases. Some states, like for example California, Florida, and Michigan, have a legal encyclopedia covering only the state. Online exercise. To find out if your state has one, search in Google, Bing, or Yahoo AA Legal Encyclopedia, substituting your state for AA. Wikipedia, wikipedia.com. Although not a legal encyclopedia, this site covers many legal topics and can provide useful links to primary authority. Just recognize its limitations. Another secondary source, which is like an encyclopedia, is American Law Reports, known as ALR. This source provides in-depth commentaries on a myriad of legal topics. The commentaries, known as annotations, are comprehensive and usually cover the law from all jurisdictions. But the annotations are selective and do not cover all legal topics. However, when an article is located on a topic of interest, it can be a treasure trove of information. ALR comes in many editions and updates its articles, but not on a regular basis. Currently, ALR has 8 series, 2 of which focus on federal law. Law reviews and legal periodicals. Law reviews are periodicals or journals that are published by law schools and contain scholarly articles from leading legal authorities and law students on various topics of interest. Notable law journals are from Harvard, Stanford, and Yale. The law review articles are extensively researched and can provide excellent background, case law, and analysis on legal topics. On the other hand, legal periodicals are journals that are often published by bar associations or special interest groups, such as the American Bar Association (ABA). These periodicals are usually topical and provide general information about areas of interest in the law. They are another good source for background information, but are less comprehensive than a law review article. Here are the main indexes to legal periodical literature found in law libraries. Index to Legal Periodicals and Books, ILP. Current Law Index, CLI. Legal Track, the online version of CLI. Google Scholar, scholar.google.com. Click articles and enter your search terms. Some of the articles will require a fee to read, but you will probably find free ones as well. Legal treatises. A legal treatise generally focuses on one specific area of law, such as contracts, torts, or property. Treatises vary regarding their persuasiveness and influence. Some works are so widely respected that they have been cited by courts such as Williston on contracts, Whittemore on evidence, or Prosser on the law of torts. Practice guides and form books. Guidebooks for the practice of law are known as practice guides or form books. They provide general commentary of a subject along with standard forms and checklists for preparing documents and pleadings in particular areas of law. Practice guides range in being state-specific or topic-specific and everything in between. They are a practical tool for practicing legal professionals. Legal dictionary. A legal dictionary provides definition of legal terminology. They are an invaluable tool and may be cited by a court when needed to define a term in a case. For example, the most widely used legal dictionary is Black's Law Dictionary. Opinion of the Attorney General. Attorney General opinions respond to inquiries from federal and state officials. Each state and the U.S. government has an Attorney General. They are opine on a particular question of law and provide guidance on areas that often have not been decided by a court. They are legal guidance until a court issues a decision on the topic. Thus, an Attorney General's opinion is a secondary source and is always superseded by a primary source of law, such as a case decision or statute. 9-6D. Reports and Reports and studies of special interest groups. There are special interest groups for almost every area of the law, like, for example, unions, bar associations, environmental associations, tax associations, insurance, and other business associations. They often have position papers and studies. Although one-sided, such literature should not be ignored. The best place to find this literature is on the websites of the organizations. A wealth of links and information is often available in these papers and studies, waiting to be sifted through. Examples: seeking an overview of adoption law, check the many reports and policy statements of the National Council for Adoption, www.adoptioncouncil.org. Seeking an overview of tobacco litigation, check the website of a tobacco manufacturer, like for example, www.altria.com, and an anti-smoking organization, like for example, https://truthinitiative.org. 9-6E Reports and Studies of Administrative Agencies. Many legal problems involve an administrative agency of the federal, state, or local government. If you go to the website of the agency, you will often find summaries of the law that governs the agency. There may also be links to reports or studies that directly pertain to the subject of your research. 9-6F Reports of Legislative Committees. If you already have the site to a statute that you think will be relevant to your research, find out if one or more committees of the legislature wrote committee reports on the statute before it was enacted into law. The reports often provide invaluable overviews of why the statute was passed and what it does. If you know the popular name of the statute, like for example, Civil Rights Act of 1964, enter it in Google, Bing, or Yahoo. Enter it in Google, Bing, or Yahoo, along with the phrase committee report or legislative history. See the ideas listed later in the chapter on the techniques for compiling a legislative history. An example of the use of secondary authority as persuasive authority is a judge who cites the analysis of an article in a scholarly legal periodical on an issue before the court. The court is under no obligation to agree with the article. Secondary authority cannot be mandatory authority, but cites the article with approval because the judge finds the article to be persuasive. A major value of secondary authority is the background research that it can provide when you are researching areas of law that are new to you. They are an excellent starting point for any research project. 9-7 Citation. In this section, we cover the citation of the most important primary and secondary authorities. A citation is a reference to any authority printed on paper or stored in a computer database that will allow you to locate the authority. Citation is shortened to cite, to be distinguished from site, which is a place such as a playground or a page on the internet. A citation gives you the address where you can go in the library or online to find whatever is cited. Citation rules and manuals tell you what to abbreviate in the citation, where spaces and commas must be inserted, in what order the information in the citation must be provided, when to include a parallel cite, etc. 9-7A Citation Rules. If you pick up different law books and examine the citations or similar material within them, you will notice great variety in citation form. You will find that people abbreviate things differently, do not include information in the same order in the cite, use parentheses differently, use punctuation within the cite differently, include different amounts of information in the same kind of site, etc. There does not appear to be any consistency, yet, in spite of this diversity and confusion, you may be admonished for failing to use proper citation form. What, you may well ask, is proper? Start by checking the court rules or statutes governing the court that will have jurisdiction over the problem you are researching. They may or may not contain official citation rules, which tell you how you must cite authorities within documents submitted to courts. If official citation rules exist, they must be followed no matter what any other citation guide may say. The rules are, in effect, citation laws. Official citation rules might also be found in official style manuals. Examples: Writing Manual, Supreme Court of Ohio, www.supremecourt.ohio.gov/rod/manual.pdf. New York Style Manual, www.nycourts.gov/reporter/new Steeman.htm. California Style Manual, www.sdap.org/downloads/style manual.pdf. Online exercise. Determine whether your state has an official citation manual or citation rules to follow when presenting legal authority to the court. If so, identify the name of the source and its citation. Place in your portfolio binder. 9-7B, Blue Book and ALWD Guide. Suppose, however, that there are no official citation rules in your state. In such circumstances, ask your supervisor what citation format you should use. You may be told to use one of the two major citation guidebooks: the Blue Book, A Uniform System of Citation, Harvard Law Review Association, www.legalbluebook.com, www.law.cornell.edu/citation, ALWD, Guide to Legal Citation, Association of Legal Writing Directors, www.alwd.org. The Blue Book BB is the older of the two guidelines. A job ad posted on a paralegal's manager's site called for an individual with exceptional blue booking skills. At one time, there were minor differences between the citation rules in the BB and in the ALW guide. Beginning in 2014, this is no longer true. The two guides are now substantially alike in their requirements for proper citation format. Excellent overviews of these citation guides are available online through video tutorials on citation format and law school websites such as www.law.cornell.edu/citation and guides.library.harvard.edu. The beginning pages of the Blue Book are called Blue Pages. These pages cover the citation formats used in everyday practice. After the Blue Pages, you will find the citation formats used by law reviews and journals of law schools. For example, law reviews often use large and small caps in their abbreviations, like, for example, GA code ANN, whereas everyday memorandum and brief writing in a law office uses a standard cap format, GA code ANN. If you go to the pages covering your state, in the back of the Blue Book, you will find a list of citation formats for every major category of law. You can find the Blue Book online at www.legalbluebook.com, but access may require a subscription. There is a quick style reference guide for general guidance on proper citation form. The ALWD Guide to Legal Citation is arguably more user-friendly and does not have as much material for the specialized needs of law reviews. The guide also covers the citation formats for the major categories of law in your state. Similar to the Blue Book, ALWD has a website, www.alwd.org, but it has limited access for free information. 9-7C, General Citation Guidelines. Before examining specific citation rules, review the General Citation Guidelines. 1. Find out if there are official citation rules in the court rules or statutes that govern what you are trying to cite. The following sites will let you know if such laws exist in your state: www.law.cornell.edu/citation, www.accesstolaw.com. 2. Ask your supervisor if they have any special instructions on citation form. What guidelines should you follow? The Blue Book or ALWD. 3. Consult the specific citation guidelines presented below. Most of these rules are based on the Blue Book and ALWD. 4. Remember that the functional purpose of a citation is to enable readers to locate your citation in a library or online. You must give enough information in the site to fulfill this purpose. 5. At the beginning of some books, you will be told how to cite the book. Cite this book as ignore this instruction. Instead, follow the guidelines above. 6. When in doubt about whether to include something in a citation, after carefully following guidelines above, resolve the doubt by including it in the cite. 9-7D, Citing Court Opinions, Cases. Court opinions, cases, are printed in volumes called reporters. Official reporters are printed by or under the authority of the government. The cite to an official reporter is called an official cite. Unofficial reporters are printed by commercial publishing companies without special authority from the government. The cite to an unofficial reporter is called an unofficial cite. There are numerous reporters for the courts, from the U.S. Supreme Court to all state courts. A brief examination of those reporters is warranted before we focus on understanding how to cite court opinions. U.S. Supreme Court cases. Official reporter, U.S. reports, cited as U.S. Unofficial reporter, Supreme Court reporter, cited as S.CT. Lawyer's edition, cited as L.ED or L.ED2D. Federal cases. Official reporter, Federal Circuit Court of Appeals, Federal reporter, cited as F or F.2D or F.3D or F.4th, contains cases from the United States Courts of Appeals. Official reporter, District Court cases. Federal supplement, cited as F.SUPP, F.SUPP 2D or F.SUPP 3D, contains cases from all the U.S. district courts from all states and territories. Additional federal case reports that you may encounter in your research are Federal Rules Decision, cited as FRD. This reporter publishes U.S. District Court cases that address procedural and evidentiary issues, such as those found in the Federal Rules of Civil, Criminal, and Appellate Procedure, as well as the Rules of Evidence. The Federal Appendix is cited as F.APPX, Blue Book, or Fed.APPX, Westlaw. This reporter was published between 2001 and 2021. It reported unpublished cases from the federal courts of appeals which are not presidential. These non-presidential cases are still available on the courts' websites, as well as many fee-based sites such as Westlaw and LexisNexis. State reporters. Many state decisions have multiple case reporters, and familiarity with your state reporters is encouraged. Many state decisions have multiple case reporters, and familiarity with your state reporters is encouraged. However, of general note are the cases from the National Reporter System, which groups states into regions. See Exhibit 9-3, the National Reporter Map. Some states have adopted the National Reporter as the official case reporter, while others have not. You can always find a reported case in the National Reporter System for your state. The National Reporter System is grouped into 7 regional reporters. They are Atlantic Reporter is cited as A. or A.2D. States in the Atlantic Reporter are Connecticut, Delaware, District of Columbia, Maine, New Hampshire, New Jersey, Pennsylvania, Rhode Island, and Vermont. Northeastern Reporter is cited as N.E. or N.E.2D. States in the Northeastern Reporter are Illinois, Indiana, Massachusetts, New York, and Ohio. New York has an additional regional reporter, the New York Supplement. It is cited as NYS or NYS2D. Northwestern Reporter is cited as NW or NW2D. States in the Northwestern Reporter are Iowa, Michigan, Minnesota, Nebraska, North Dakota, South Dakota, and Wisconsin. Pacific Reporter is cited as P or P.2D or P.3D. States included in the Pacific Reporter are Alaska, Arizona, California, Colorado, Hawaii, Idaho, Kansas, Montana, Nevada, New Mexico, Oklahoma, Oregon, Utah, Washington, and Wyoming. Note, California also has another unofficial reporter, California Reporter. It is cited as CAL.RPTR or CAL.RPTR.2D. Southeastern Reporter is cited as S.E. or S.E2D or S.E.3D. States included in the Southeastern Reporter are Georgia, North Carolina, South Carolina, Virginia, and West Virginia. Southwestern Reporter is cited as SW or SW2D or SW3D. States included in the Southwestern Reporter are Arkansas, Kentucky, Missouri, Tennessee, and Texas. Southern Reporter is cited as SO or SO2D or SO3D. States included in the Southern Reporter are Alabama, Florida, Louisiana, and Mississippi. Quick tip: do not cite the Southern Reporter as S. That is incorrect. Its citation is SO. That is a mistake many legal professionals make when citing that reporter. Exhibit 9-3, National Reporter System Map. Regional reporters, state cases. Pacific, Northwestern, Southwestern, Northeastern, Southern, Southeastern, Atlantic. National Reporter System Map, showing the states included in each reporter. Source: University of Washington School of Law. Let's now focus on a specific case citation and its specific components. Here, for example, is a citation of the landmark case of Miranda v. Arizona, which requires the police to inform people in custody of their rights to remain silent and entitlement to an attorney in the official reporter, U.S., and in two unofficial reporters, S.CT and L.ED.2D. Miranda v. Arizona, 384 U.S. 436 86 S.CT 1602 16L ED 2D 694 1966. In this site, U.S. is the abbreviation for United States Reports. The official reporter for cases of the U.S. Supreme Court, S.CT, is the abbreviation for Supreme Court Reporter, which is an unofficial reporter. L.ED.2D is the abbreviation for the United States Supreme Court Reports. Lawyer's Edition, Second Series, which is another unofficial reporter. In a cite to a case, the number to the left of the abbreviation of the reporter is the volume number of the reporter. The first number to the right of the abbreviation of the reporter is the page number of the reporter, where the case begins. Hence, in the Miranda cite, 384 is the volume number of U.S. reports. U.S. containing the Miranda case. 436 is the page number of U.S. reports, U.S., where the Miranda case begins. 86 is the volume number of Supreme Court reporters, S.CT, containing the Miranda case. (1602) is the page number of Supreme Court reporter, S.CT, where the Miranda case begins. 16 is the volume number of Lawyer's Edition 2D series, L.ED 2D, containing the Miranda case. 694 is the page number of Lawyer's Edition 2D series, L.ED.2D, where the Miranda case begins. Parallel cites. A parallel cite is an additional citation where you can find the same written material in the library online. Hence, for the Miranda v. Arizona case, 86SCT 1602 is a parallel cite of 384 U.S. 436. 16L ED.2D 694 is another parallel cite of 384 U.S. 436. If the opinion is also available online, the cite would be an additional parallel cite to the cites in paper volumes. Exhibit 9-4 contains another example of a citation to an opinion with parallel cites. Cashin v. Span 66NJ 541 334 A.2D 8 1975. Exhibit 9-4 Components of a typical case citation. name of parties, official site, unofficial site, date of opinion, Cashin vs. Span, volume number of New Jersey reports, abbreviation of the reporter, New Jersey reports, page number in New Jersey reports in which the Cashin opinion begins, volume number of Atlantic Reporter, second series, abbreviation of the reporter, Atlantic Reporter, second series, page number in Atlantic Reporter, second series on which the same Cashin opinion begins. The date of the opinion is provided in the parentheses, but not the abbreviation of the name of the court that wrote this opinion. If one of the reporter abbreviations is also the abbreviation for the state, then the opinion was written by the highest state court in the state. You know that Cashin was written by the highest state court in New Jersey because the abbreviation of one of the reporters, NJ, is also the abbreviation of this state. Official site 66NJ541. Unofficial site 334A2D8. Date of opinion 1975. The 1975 case of Cashin vs. Span is printed in two reporters. New Jersey Reports, abbreviated NJ, the official reporter, and Atlantic Reporter 2D, series abbreviated A.2D, the unofficial reporter. When to include the name of the court in a case citation. The citations to Miranda v. Arizona and to Cashin v. Span include a date in parentheses at the end of the citation, 1966 and 1975. In other citations, the parentheses will also include an abbreviation of the court that wrote the case. This is not needed, however, for the Miranda and Cashin cases. Here is why. If one of the reporters is abbreviated by the name of the state, like for example NJ, CAL2D, you know that the case was written by the highest state court in the state. Hence, you know the Cashin was written by the highest state court in New Jersey, Supreme Court of New Jersey, because the reporter abbreviation in 66NJ541 is the abbreviation of New Jersey. If US is the abbreviation of one of the reporters in the site, you know that the case was written by the U.S. Supreme Court. You know that Miranda was written by the U.S. Supreme Court because U.S. is in the abbreviation of one of the reporters, 384 U.S. 436. Sometimes you will find an abbreviation of a court in the parentheses before the date. Let's look at three examples. Snusky vs. Wright, 751 NYS 2D 344 SUP CT Niagara CO 2002. The abbreviation of the reporter NYS 2D is not the abbreviation of New York State NY. Hence, you know that Snusky was not written by the highest state court in New York, which is the New York Court of Appeals. The reader, therefore, needs to be told in the parentheses what court wrote it. The Snusky case was written by the Supreme Court of Niagara County. The abbreviation for this court is SUP CT Niagara CO. The reporter in this site is NYS 2D, New York Supplement 2D Series. In New York, the Supreme Court is not the highest state court. In RE Estate of Hewitt, 721 A.2D 1082 PA 1998. The abbreviation of the reporter A.2D is not the abbreviation of any state. The reader therefore needs to be told, in the parentheses, what court wrote the Hewitt case. It was written by the Supreme Court of Pennsylvania. You can abbreviate the highest state court by using the abbreviation of the state. The abbreviation of Pennsylvania is PA. This abbreviation, therefore, is used in the parentheses for the highest state court in Pennsylvania. The highest state court in a state is always the abbreviation of that state. Here, PA. The reporter in this site is A.2D, Atlantic Reporter 2D Series. McHenry vs. Florida Bar 21F.3D 1038, 11th Circuit, 1994. The abbreviation of the reporter F.3D is not the abbreviation of any state court. The reader, therefore, needs to be told, in the parentheses, what court wrote the McHenry case. It was written by the U.S. Court of Appeals for the 11th Circuit, abbreviated 11th Circuit. The reporter in this site is F.3D, Federal Reporter 3D Series. When to include a parallel site. In the examples we have seen thus far, you will note that some parallel sites and some do not. For most citations, you do not need a parallel site. We will cover when they are required in this section below, called More Examples of Case Citations. Citation to a portion of a case. Sometimes you will want to refer the reader to a particular case, perhaps a quotation of the judge. Here again is our citation of Cashin. Cashin vs. Span, 66 NJ 541334 A.2D 8 1975. Assume that the quote is on page 554 of New Jersey Reports, NJ, and on page 14 of Atlantic 2D Series, A.2D. In the citation, you would pinpoint these page numbers by including them after the page numbers on which the opinion begins. Here is how the citation would look. Cashin vs. Span, 66 NJ 541554 334 A.2D 814-1975. The reference to specific material within a document, in addition to the citation of the entire document, is called a pinpoint cite. Public domain sites, the case citations we have examined thus far, contain a volume and page number. A volume and page citation is referred to as a traditional citation. In the following traditional Illinois citation of Wirtz v. Quinn, decided in 2011, the reporter is Non-Eastern Reporter. 2D Series, abbreviated NE2D. The case is found on page 899 of volume 953 of NE2D, as in all traditional citations. The year the case was decided is given in parentheses at the end of the citation. Wirtz v. Quinn, 953 NE2D 899 I-11 2011. In some courts, there is an additional citation format that is not dependent on volume and page numbers of reporters. It is called a public domain citation. Illinois uses such citations. Here again is a citation to the same case of Wirtz v. Quinn, this time using a public domain citation. Wirtz v. Quinn, 2011 IL 111903. Note the differences between the traditional citation TC and public domain citation PDC of this case. There is no volume number in the PDC. Instead, it uses the year the case was decided, 2011. There is no abbreviation of a reporter in the PDC. Instead, the state is abbreviated as IL. There is no page number in the PDC. Instead, there is a number assigned by the court to the entire case, 111903. The special abbreviation for the state in the PDC is IL. Its abbreviation in the TC is ILL. Both are abbreviations of the state. Hence, we know that the case was written by the highest state court in Illinois, the Illinois Supreme Court. The number assigned to the case by the court. (111903) is a consecutive number, so that the next case issued by the court in 2011 will be assigned number 11904, 2011 IL 111904. The one after that will be 111905, etc. Not all courts have PDCs, and those that have them do not have the same format, although they will be similar to the format in Illinois. When a court starts using PDCs, it will number each paragraph 1, 1, 2, 3, etc. Before this time, paragraph numbers were not numbered in this way. If you wanted to quote or refer to something in 6.4 of the opinion, you would pinpoint this number. The pinpoint site of a case with a PDC, therefore, would look like the following: Wirtz v. Quinn, 2011 IL 111903, 6.4. Most opinions that have a PDC also have a TC. They are parallel sites to each other. If both exist for a case, provide both. The Wirtz case has a PDC and a TC. Hence, here is its citation. Wirtz v. Quinn, 2011 IL 111903, 953 NE2D 899. There is no need to include the parentheses I11 2011 in a site that includes both a PDC and a TC. The year is already included as part of the PDC. There is also no need to include the name of the court that wrote the opinion. You know that the highest court in the state wrote the opinion because one of the abbreviations of the reporters is also the abbreviation of the state IL. Finally, let's look at this site with pinpoint references. Assume that you wanted to quote a sentence that is in 57 of the PDC and on page 910 of the TC. Here is the pinpoint site you would use. Wirtz v. Quinn, 2011 IL 111903, 57953 NE2D 899910. Online exercise. Determine whether your state uses the public domain format. If so, when did your state begin using this format for case citation? More examples of case citations. Let's look at some additional case citation examples. In the examples A-Z, A-G, note when parallel sites are included and when they are not. Here are the guidelines on when they must be included. Citations to federal court cases do not need a parallel site. See examples A, B, and C. Citations to state court cases do not need a parallel site unless the rules of the court where you are submitting the document containing the citation require parallel sites. If the court uses public domain citations, include the parallel site. Example A. Format of a citation to an opinion of the highest federal court. The U.S. Supreme Court in the United States reports U.S. Taglianetti v. United States, 394 U.S. 316, 1969. Earlier, we included parallel cites for the U.S. case of Miranda v. Arizona. This was done to show you what parallel cites are, but such cites are not required. Example B. Format of a citation to an opinion of a federal intermediate appellate court. The U.S. Court of Appeals for the Second Circuit in Federal Reporter 3D Series F.3D. Podell v. City Corp. Diners Club Incorporated 112 F.3D 982D Circuit 1997. Example C. Format of a citation to an opinion of a federal trial court. The U.S. District Court for the District of Pennsylvania, Eastern District, in Federal Supplement 2D Series F. SUPP 2D. Note that the specific district of the court is cited, which is the Eastern District cited as ED. Stratton v. Marsh 7-1 Federal Supplement 2D 476 Eastern District, Pennsylvania, 1999. Stratton v. Marsh 7-1 F SUPP.2D 476 ED PA 1999. Example D. Format of a citation to an opinion of the highest state court, California Supreme Court, that is printed in 3 reporters. California Reports, 4th Series, CAL 4th, California Reporter 2D, CAL Reporter 2D, and Pacific Reporter 2D Series P.2D. Assume that a parallel cite is required. People v. Sargent, 19 CAL 4th 1206, 81 CAL RPTR 2D 835 970 P.2D 409 1999. Example E. Format of a citation to an opinion of a lower state court, Connecticut Superior Court, Appellate Session, printed in Connecticut Supplement CONN SUPP. Assume that a parallel cite is required. Huckabee v. Stevens, 32 CONN SUPP 511 338 A.2D 612 Super.CT.1975. Example F. Format of a citation to an opinion of a lower state court, Connecticut Superior Court. That includes a pinpoint cite. The pinpoint cites in example F are 520 for the CONN SUPP reporter and 632 for the A.2D reporter. Huckabee v. Stevens, 32 CONN SUPP 511 520 338 A.2D 612 632 Super CT 1975. Example G. Format of citation that includes a public domain citation to an opinion of the Supreme Court of Maine in Atlantic Reporter 2D Series A.2D and a pinpoint citation to the third paragraph, which is also on page 599 of A.2D. Pine Ridge Realty Incorporated v. Mass Bay INS CO 2000 ME 1063752 A.2D 595 599. Online exercise. Locate examples of case citations for your state. Check your state's highest court website's rules for citations. Also check online examples of citations of state cases for your state on www.law.cornell.edu/citation Try a Google, Bing, or Yahoo search by entering your state, followed by the citation rules. 9-7E, citing constitutional law. Constitutions are cited and abbreviated. Name of the Constitution, the article ART, number and the section, statute number. US const.art.I, statute 9. NM const.art.IV, statute 7. When citing constitutions currently in force, do not give the date of enactment. Give the date only if you are citing a provision that is no longer in effect. 9-7F, citing statutes. Citing federal statutes. The federal statutes of Congress are published in 3 main sets of codes. United States Code, USC, published by the government. United States Code, annotated USCA, published by West Thomson Reuters, and United States Code Service, USCS, published by LexisNexis. Citations begin with a title number, followed by the abbreviation of the code, then the section, statute number of the statute being cited, and ending with the date in parentheses. Mention the name of the publisher only for USCA and USCS. Here are examples of the citation of the same statute in each of the 3 codes. 42 USC Statute 3402, 2006. 42 USCA Statute 3402, West 2012. 42 USCS Statute 3402, LexisNexis 2013. Note that citing the year is optional. However, if you cite the year to use is the year the volume you are using was published, not the year the statute was enacted. Citing state statutes. Citations to state codes vary from state to state. Here are some examples. FLA STATANN Statute 23.8911 2010. CAL.FAM.COD Statute 100 West 2008. For the citation format you should use for your state, check state rules for citation in your state, if any. The charts for your state in the Blue Book and in the ALW also go to www.law.cornell.edu/citation. 9-7G, citing administration regulations. Citing federal administration regulations. Federal administrative regulations are published in the Federal Register, FED-REG. Cites to the FED-REG Federal Register are to the volume number of the register, the abbreviation of the register, the page number in that volume that contains the regulation, and the full date of the register. Example: 77 FED-REG 2092, March 13, 2013. Many federal regulations are later codified in the Code of Federal Regulations, CFR. When any group of law is codified, the laws are arranged in a systematic order, usually by subject matter, regardless of when they were enacted. The noun is codification. Cites to the CFR are to the title number of the code, the abbreviation of the code, the section number of the regulation, and the year of the code you are using. Example: 29 CFR Statute 102.60A 2023. Citing state administrative regulations. The format for citing state administrative regulations is similar to the format used for federal administrative regulations. Both the Blue Book and the AWLD have a table that gives the name of the administrative code and register of every state. To see online examples of citations of state administrative regulations for your state, go to www.law.cornell.edu/citation. Here is an example of a state regulation published in a register, Massachusetts, and one published in an administrative code, Virginia, 1136 MASS. Register 26 August 7th, 2009. 4 VA Admin Code, Statute 15-40-140-2023. 9-7H Citing Other Authorities, Administrative Decision, National Labor Relations Board. Example, Standard Drywall Products Incorporated, 91N.L.R.B 544/1950. Court Rules, Federal Rules of Civil Procedure. Example, Fed.R.Civ P.11. Executive Orders. Example, Exec.Order No.12893, 3 CFR 359/1992. Opinions of the Attorney General. Example, 36OP.ATTYGEN.237/2012. Annotations in American Law Reports, ALR. Example, James J. Watson. Annotation, Attorney's Fees, Cost of Services Provided by Paralegals, 7-3 ALR 4th 938 1989. Legal Treatise. Example, Joseph M. Perillo. Contracts, 7th ED 2014. Legal Periodicals. Example, William P. Statsky. The Education of Legal Paraprofessionals, Myths, Realities, and Opportunities. 24 VAND LRV VAND.L.REV.1083 1971. Legal Encyclopedias. Examples, 8-3 CGS Subscriptions Statute 3, 2006, year of publication. 7 AM JUR 2D Vendor and Purchaser Statute 73, 2007, year of publication. Restatement. A restatement is a special category of legal treatise of the American Law Institute that states the law and indicates changes in the law that the Institute would like to see implemented. Example, Restatement, 2nd, of Torts, Statute 37, 1965. Restatement, 3rd, of the Law Governing Lawyers, Statute 159C, 2000. 9-7I, Citing Online Sources. When do you want to cite something that exists only online? Provide 1. The name of the author if given. 2. The title or top-level heading of the material you are citing. 3. The Uniform Resource Locator URL, which is its website. 4th, the date of the site if available. And 5. The date you last visited the site. Example, NALA, the Paralegal Association certification, www.nala.org, last visited August 16th, 2023. Online exercise. Search on www.legalbluebook.com for the Quick Style Guide. Prepare the citation for that online source. Social media. Social media and the search for information and verification of cited information. part of a legal research process has now become checking social media sites for information about a case. It is part of the required due diligence process that must be performed, especially in the litigation process. Foregoing social media searches may be tantamount to malpractice, as critical information will be lurking in those sites. Checking sites such as Facebook, X, formerly known as Twitter, Instagram, TikTok, and other social media sites have now become a standard component of background research on a client's case. As we have discussed throughout this chapter and this book, documenting your social media research trail is important. How was the site identified? How was the information captured and authenticated? Because social media content is constantly changing, be sure you carefully identify where and how you found the information, including the site URL and when the site was visited, date and time. So once that information is discovered, how do you formally cite that information in a legal document? Unlike visiting a website, citing a social media site is different. The information for social media citations follow the Blue Book Rule 1.8, which covers internet, electronic media, and other non-print sources. As noted in the text, provide 1. The name of the author, if given. 2. The title or top-level heading of the material you are citing. 3. The Uniform Resource Locator, URL, which is its website. 4. The date of the site, if available. And 5. The date you last visited the site. There are variations to citing social media, depending on the information available, which may include the username, handle, or author of the information, /post, /tweet, and title. This is followed by the name of the social media site, the date of the post, and time. And as noted above, include the URL of the post at the end. The point of any citation is to be able to find the material cited and verify its authenticity. Keep that in mind when you are citing social media or researching social media information. Another source for citing social media is the MLA Handbook. Some jurisdictions use this handbook as the basis for citing social media sites. It follows some of the same principles as the Blue Book, with the same purpose for cited material. Finding it and verifying it. Verify your jurisdiction's citing authority for social media. Do not assume it is Blue Book. 9-8 Site checking. Documents such as a memorandum of law, appellate brief, and motion often contain many citations. Site checking, such as documents, requires an examination of each citation in the document to determine its accuracy. For example, you want to make sure that the format of the citation is correct. Parallel cites are provided. Quoted material is accurately quoted. Cases cited have not been reversed or overruled. Statutes cited have not been amended, repealed, or declared unconstitutional. Administrative regulations cited have not been amended, repealed, or declared unconstitutional. In a site-checking assignment, you are given a document written by someone else and asked to check the citations provided by the author of the document. Although our focus in this section will be site-checking documents written by others, the guidelines discussed here are in large measure equally applicable to your own writing, subjecting what you have written to your own criticism, and review is called self-editing. 9-8A Guidelines for Site Checking. 1. The first step is to obtain clear instructions from your supervisor on the scope of the assignment. Should you do a light check that merely makes sure that the format of the citations is correct, Or should you do a comprehensive check that includes checking citation format, finding and inserting needed parallel cites, checking quotation accuracy, and determining the current validity of the laws cited? The remaining guidelines assume that you have been asked to do a comprehensive check. Most documents will be electronic. Make sure that you have a copy of the document on which you can make comments. Documents, edits, and corrections normally will be redlined through some type of software program on Word or WordPerfect. Use the strikeout key for whatever you want to remove from the document. These format notations make it easy for the writer of the document to scroll through it and find your additions and omissions. The track changes feature of word processing programs such as Word will automatically insert the format notations for you. These programs also allow you to include margin comments in which you explain why you made a particular change. In the remainder of these guidelines, we will assume that you are doing the cite check in the traditional way, on paper rather than entirely on the computer. 3. For those that prefer working from a paper document, do not use the original document. Make a copy to edit and correct the citations. If the pages of the document already have pencil or pen markings made by others, or by the author who made last-minute insertions, use a pencil or pen that is a different color from all other markings on the pages. In this way, it will be clear to a reader which corrections, notations, or other comments are yours. If you find that you do not have enough room to write in the margins of the pages, use separate sheets of paper. You can increase the size of the margins by photocopying the document on a copier that will reduce the size of what it is copied. 4. If the document will be submitted to a court, be sure that you are using the court's official citation rules, if any, that must be followed for all citations and documents submitted to that court. If official citation rules do not exist, find out what rules or guidelines on citation format the supervisor wants you to use. Blue Book, another format. 5. Before you begin, try to find a model by going through old case files in the office. You may be able to locate a prior document, such as an old appellate brief, that you can use as a general guide. If it still has the markings and notations on it made by the person who cite checked it, ask your supervisor to direct you to such a document. Although it may not cover all the citation variations you will encounter in your own document, you will at least have a general guide approved by your supervisor. 6. Check the citation format of every cite in the document. This includes any cites in the body of the text, the footnotes or endnotes, the appendix material, and the introductory pages of the document, such as the Table of Authorities, TOA, at the beginning of a brief. A table of authorities is a list of the primary and secondary authority the writer is using in an appellate brief or other document. The table will indicate on what pages in the document each authority is discussed or mentioned. Be sure that these page references are accurate. For more on TOAs, see Chapter 10. 7. For long documents, you will need to develop your own system for ensuring the completeness of your checking. For example, you might want to highlight electronically, or if using hard copy, circle every cite that you have checked and found to be accurate, and place a small box around or question mark next to every cite that is giving you difficulties. You will want to spend more time with the latter, seeking help from colleagues and your supervisor as needed. 8. When you find errors in the form of the citation, make the corrections through redlining or in the margin of the pages where they are found. 9. For some errors, you will not be able to make the corrections without obtaining additional information, such as a missing date or a missing parallel site. If you can obtain such data by going to the available online resources or relevant library books, do so. Otherwise, make a notation either through an online comment or in the margin of the hard copy of what is missing or what still needs correction. 10. Consistency in citation format is extremely important. On page 2 of the document, for example, the author may use one citation format, but on page 10, they may use a slightly different format for the same kind of legal material. You need to point out this inconsistency and make the consistency corrections that are called for. 11. Often, your document will quote from cases, statutes, or other legal materials. For example, the document may quote a sentence from a case and give this pinpoint cite to the case. Miranda v. Arizona, 384 U.S. 436 451 1966. The quoted sentence should be on page 451 of the Miranda case. Check the accuracy of these quotations. Go to the material being quoted and find the quote. Confirm that it is on page 451. Now check the quote itself line by line, word by word, and punctuation mark by punctuation mark to be sure that the document is quoting the case accurately. Be scrupulous about the accuracy of quotations. 12. If available to you, use standard citators, like for example, Shepard's citations or KeyCite to check the cites. We will discuss citators later in the chapter. 13. Check the accuracy of every supra reference. Supra means above or earlier. It refers to something already mentioned and cited. In the document, you are cite checking. For example, assume that footnote 8 on page 23 of the document contains the following cite. 8. Robert G. Dana, Family Law 119, 1992. The particular reference is to page 119 of Dana's book. Now assume that 10 pages later, in footnote 17, the document again refers to Dana's book, this time to page 35. A full citation to this page would be as follows. 17. Robert G. Dana, Family Law 35, 1992. But a full citation is not needed. You can use a short form citation. This is an abbreviated citation of an authority that you use after you have already given a full citation of that authority earlier in the document. For the short form citation of a legal treatise such as the Dana book on family law, use the author's last name followed by the supra reference. 17. Dana, supra note 8 at 35. This means that the full cite of the Dana's book was already given earlier, supra, in the document in footnote 8. There is no need to repeat the full cite. The cite checker must simply go to footnote 8 and make sure that the full cite of the book is provided here. 14. Check the accuracy of every infra reference. Infra means below or later, and refers to something that will come later in the document. In the same manner as you check the supra references, you must determine whether the infra references are accurate. 15. Check the accuracy of all of short-form case citations. Assume that in the body of the document the following reference is given. Sierra Club vs. Sigler, 695 F 2D 957 980, 5th Circuit, 1983. The pinpoint cite is to page 980 of the Sierra Club opinion, which begins on page 957 of the Federal Reporter, 2nd Series, Volume 695. Now assume that the author wants to refer to page 962 of the same case later in the document. As with the Dana book example, there is no need to repeat the entire citation. The following short form may be used: Sierra Club 695F 2D at 962. To check the accuracy of this cite, you must go back in the document to make sure that the Sierra Club opinion has already been cited in full. 16. Do not use supra when you are citing cases. Supra can be used for many items, such as legal treatises and legal periodicals. With rare exceptions, however, do not use it in citations to court opinions. When you wish to avoid repeating the full citation of an opinion, follow the example above of the Sierra Club short form citation. 17. Check the accuracy of every ID reference. ID means the same as something previously mentioned. Use ID when you are citing an authority that is also the immediately preceding authority cited in a footnote. ID is more specific than supra. Supra means above or earlier. ID, however, means immediately above. Assume, for example, that footnote 21 in an appellate brief says 21 Kohler vs. Tugwell 292F SUPP 978 EDLA 1968, and footnote 22 says 22 ID at 985. The ID reference means that here in footnote 22 you are referring to the immediately preceding authority. The Kohler opinion in footnote 21. Technology update. ChatGPT and the non-existent citations. This technology update should be titled The Legal Shot Round the World. An attorney was sanctioned because he submitted a brief to a court that had non-existent cases cited. Yes, that means the cases were made up. A bit of background is necessary. ChatGPT is a new artificial intelligence AI that seems to be everyone's answer to a lessening workload substituted by a chat bot. Although this technology seems like everyone's panacea for having a robot do your work, as an attorney in New York City learned. What is too good to be true is just that. Too good to be true. In Meta vs. Avianca Incorporated, attorneys for the plaintiff filed a negligence action against the airline. The airline raised certain defensive issues, including that Meta did not timely file his claim and that the claim should be in federal and not state court. Meta's attorney requested additional time to respond to Avianca's motion to dismiss. Note that although Meta continued using the original law firm Levido, different attorneys from the Levido firm represented Meta in federal and state court. Because the case was removed and now heard in federal court, the original attorney, Steve Schwartz, had his partner Peter. Because the case was removed and now heard in federal court, the original attorney, Stephen Schwartz, had his partner Peter Loduca handle the federal court case. Schwartz continued behind the scenes to do all the legal work. That is where the problems began. Schwartz used ChatGPT to write his responsive brief, and Loduca filed it in the federal court. Unbeknownst to Loduca, Schwartz used ChatGPT to draft a responsive brief. After the brief was filed, Avianca's lawyers did their due diligence and checked all the cases that were cited by Mata's counsel. What Avianca's lawyers learned was that 6 of the cases were non-existent. These citations led to fake cases that were attributed to current courts and sitting judges. To put this in plain English, the cases were made up by ChatGPT. Even the quotes in the brief that Loduca and Schwartz cited were made up by ChatGPT. Neither of Mata's attorneys checked the information that ChatGPT cited in the brief for relevancy, let alone their authenticity. The sad part of the brief fiasco is that it took nearly 3 months from the original filing of the brief for Mata's lawyers to acknowledge the error of their ways. The court acknowledged that attorneys may and will use new technology, but where this case went awry was the fact that Mata's attorneys failed to check the work product of the artificial intelligence. The court cited numerous ethical rules violated and wrote a scathing opinion sanctioning the attorneys for their careless actions. The takeaway from this case is to be diligent in checking your research, no matter who does it. Do not lie to the court, clients, or opposing counsel. Do not rely on AI technology, such as ChatGPT, to perform your legal work, and above all, be forthcoming when mistakes are committed. It is worth reading Mata v. Avianca, 2023, U.S. District, Lexus 108263 FSUPP 3D 2023 WL 4114965 SDNY 2023, as it should be a cautionary tale of what not to do when performing legal research and what not to do when caught in untruths. As an aside to the case, in Lexis, there is a cautionary notice that reads, "This decision contains references to invalid citations in the original text of the opinion. They are relevant to the decision and therefore have not been editorially corrected. Linking has been removed from those citations." End of story. 9-9. The first level of legal research. There are 3 interrelated levels of researching a problem. Background research provides you with a general understanding of the area of law involved in your research problem. Background research uses secondary sources to give you the big picture, to help guide you into the specific needs of your research assignment. Specific research provides you with primary and secondary authority that covers the specific facts of your research problem. Validation research provides you with the information on the current validity of all the primary authority you intend to use in your research memorandum on the problem. At times, all 3 levels of research go on simultaneously. If you are new to legal research, however, it is recommended that you approach your research problem in 3 separate stages or levels. Our concern in this section is the first level, background research. The other 2 levels are covered throughout the remainder of the chapter. Let's break down the starting point and questions to be asked for commencing general background research. Step 1. The best place to begin background research is either through Google or a legal encyclopedia. Educate yourself on the general topic. For example, in our facts at the beginning of the chapter, the client was found sleeping in his car, intoxicated. Search for information on Google by entering terms such as DUI, parked car, sleeping. General information will appear that may be relevant. Add your state to the search and more information will appear, even cases and statutory sections. You can perform a similar search in a legal encyclopedia. The point to background research is to educate yourself on the law and the words or phrases that may be relevant to your search. With background research, it will be more generalized until you begin to understand the legal issues or implications of the facts presented to you for research. Exhibit 9-5 identifies some of the major areas of law to use as a starting point. Exhibit 9-5 Major areas of law involved in a legal research problem: antitrust, bankruptcy, children, civil procedure, civil rights, commercial, communications, constitutional law, consumer, contracts, copyright, corporations, criminal law, employment, environment, estates and probate, ethics, evidence, family, fraud, gifts, health, immigration, insurance, international, labor relations, landlord-tenant, military, municipalities, partnership, patents, public benefits, real estate, sales, securities, sports, taxation, torts, trademarks, transportation, women, other. Step 2. Based on the facts of the case that you are assigned, you need to think about what jurisdiction may apply. With a DUI, chances are that state law and statutes will apply to your facts. There may be some constitutional issues involved, but that will develop as you narrow your general research. There may be some constitutional issues involved, but that will develop as you narrow your general research. Step 3. Now that you have narrowed down the body of law that you believe will apply, determine preliminary what primary authority may apply, and therefore check based on your facts. Here we have most likely will be focused on cases and possibly state statutes on the issue. Here we have most likely will be focused. Here we most likely will be focused on cases and possibly state statutes on the issue. Other primary authority may apply, but at this point, you do not know all the details of the case, so having a general idea is sufficient. Step 4. After you have completed the general background research, it is most likely appropriate to move to the determining your more specific research, which will be followed by validation research. After you have completed the general background research, it is most likely appropriate to move to the determining your more specific research, which will be followed by the validation research. To summarize, general background research should be done to educate yourself on the general issues, information, and concepts that may be involved in your research assignment. Remember, this is the beginning of the process, and the next steps will narrow down the primary sources that will apply to your specific set of facts. Later in the chapter, we will focus on the specific legal resources that should be consulted on a legal research assignment, as well as a roadmap to guide you through the process. Let us assume you are researching a topic that is new to you. Where do you begin? What online sites do you start checking? Or law books do you take off the shelves? More specifically, should you start looking for federal law or state law? Should you begin looking for statutes or for court opinions? Should you start by checking constitutional law? Should you start by checking procedural law? Should you start by checking administrative law? Should you start by checking ordinances or other local laws? By definition, you don't know the answers to such questions. We are assuming that you have never researched a problem like the one now before you. Of course, you will want to ask your supervisor for direction on where to begin. Also, you should try to seek out a colleague who may be able to give you some initial guidance. Suppose, however, that such assistance is fairly minimal or is simply not available. Where do you begin? As a general rule, it is a good idea to start with the statutory code. Cartwheel, the major facts in your research problem. Refer to Exhibit 9-2 and try the results in the index of the statutory code, volumes, and in the search box for the online version of the code. If relevant statutes exist, you need to find them as soon as possible because they are likely to be central to the problem. Try some of the resources for doing background research outlined in this chapter. Spend an hour or two, depending on the complexity of the problem, with these resources. This will give you an overview or big picture of the areas of law involved in your research problem. With this general understanding, you will be in a better position to be able to identify the major questions or issues you need to address and where to begin or where the next step should be. Of course, while doing this background research, you will probably also come up with leads that will be helpful in the second and third levels of research. While performing your initial legal research, be aware of unique legal terminology, such as terms of art, that you will inevitably run into. Terms of art are words or phrases that have a distinct, special, or technical legal meaning. Words and phrases such as double jeopardy, strict liability, habeas corpus, or time is of the essence are all terms of art. These are important words to pay attention to while researching as they may have significance in your research. Don't overlook or ignore them. Next, we turn to the second level of research, finding specific primary authority that applies to your facts. Your facts. Next, we turn to the second level of research, finding specific primary authority that applies your facts. Our overview will cover finding cases, statutes, constitutional law, administrative law, court rules, local law, and international law. 9-10, Finding the law. The goal in the search for case law is to find cases on point or analogous. Your starting point is a set of facts in a client matter or in a class assignment. You want to find case law opinions that cover similar facts and issues. The words case and opinion are interchangeable. For a list of state and federal courts that write opinions, see Chapter 7. See also the material in Chapter 8 on the structure and kinds of court opinions. Also, review this chapter's contents on the different reporters and citations formats as well. (9-10A) Digests and annotation. The two major traditional case finders are digests and annotations. A digest is a set of volumes that contain brief summaries of points of law and court opinions. These summaries come from headnotes at the beginning of court opinions. In Chapter 8, we saw examples of headnotes and explained how the digests can be used to find case law through the key number system. You should review that material. Most states have individual digests that allow you to search for case law from courts in their state, like, for example, California Digest, New York Digest. In addition, there are national digests that are part of the American Digest system, which covers every federal and state court in the country. The index to these digests is called the Descriptive Word Index, DWI. This index will allow you to find key numbers for the issues you are researching. The key numbers are then used in the main volumes of the digest to find the case summaries. The key numbers are then used in the main volumes of the digest to find the case summaries. The key numbers are then used in the main volumes of the digest to find the case summaries. The publisher of the digests is West Thomson Reuters, which also makes them available on Westlaw. Another major traditional case finder are the annotations in the volumes of American Law Reports, ALR. As mentioned earlier, an annotation is akin to a research paper. In the volumes of ALR, there are thousands of annotations on a wide variety of legal issues. In each annotation, you will find one case printed in full, plus an extensive research paper that summarizes hundreds of cases from all courts on the main issue covered in the annotation. To find an annotation on the issues you are researching, the main index to use is called ALR Index. The publisher of ALR annotations is West Thomson Reuters, which also makes them available on Westlaw and on LexisNexis. As we have learned, research is important in the practice of law. Our next case for review is about a prisoner upstaging an assistant attorney general. For our purposes, it is a case of what not to do when preparing a memorandum of law to the court. Do the work and the research. The attorney was admonished by a judge for failing to find leading cases on a matter he was handling where the opposing party, an inmate, performed more complete research than the attorney. Let's review Salahuddin v. Coughlin, 999 FSUPP.526 SDNY 1998. Order of the Court, a case study. Salahuddin v. Coughlin, U.S. District Court for the Southern District of New York, 999 FSUPP 526 SDNY 1998. Salahuddin v. Coughlin is about access to religious services by an inmate. Richard Salahuddin was a prisoner within the New York correction system. Along with other inmates, Salahuddin filed actions against prison officials claiming denial of access to religious services. He claimed he was discriminated against as a Muslim because others were permitted to practice their religion where he was not. Salahuddin was involved in a transfer to another facility which was not equipped to have religious services. Salahuddin was considered a keep-locked inmate. This was an inmate who had violated certain prison policy and was in confinement. This was a central issue before the court, as that was one of the reasons he was denied participation in religious services. Summary judgment motions were filed by the defendants, New York correctional officials, who were represented by an Attorney General, AAG, from the New York Attorney General's office. The case was appealed to the Second Circuit Court of Appeals that found that prisoners have a constitutional right to participate in religious services. Although not absolute, inmates who are keep-locked inmates cannot be deprived of that right. The case was remanded back to the district court to address whether the denial of Salahuddin participation in religious services was reasonable and whether it was reasonable to transfer inmates who regularly participated in religious services when it was known that the other facility did not have the means to have religious services. One of the issues the court noted had not been raised was the issue of qualified immunity. Before the court was a motion for summary judgment filed by the defendant, Correctional Department. In its decision, the court focused on the misstated and misguided research of the Assistant Attorney General. The law that he was citing was incorrect, and cases nearly 15 years before had established rights of prisoners and when the principle of qualified immunity would apply. What the court spotlighted was a 1996 decision by Judge Jones in a related opinion. The AAG did not cite Judge Jones's decision and other related decisions that showed that their position was wrong. In fact, the court complimented Salahuddin's pro se brief that accurately stated the case law and provided coherent analysis, contrary to the AAG in the case, citing the Second Circuit presidential case law that the AAG missed. The court reflected on the accuracy and clarity of Salahuddin's brief. On the other hand, the AAG cited law that was not applicable, current, or supportive of the arguments that he attempted to make in his brief. The result was that the court admonished the AAG for poor research, failure to shepherdize, failure to search applicable keynotes, or a viable word search. The court ordered the AAG to show cause why sanctions should not be imposed for his failed and lacking research. Not a good result for the lawyer. Discussion questions. Examine Salahuddin versus Coughlin. What is the case history of this matter? Which cases did the court state the AAG failure to cite, and why were they important? What conclusions in the law did Judge Jones reach in his earlier decisions related to this matter? Did the court grant the summary judgment motion? If so, what was the result? 9-10B. Where can you find and read federal cases? Cases can be read in print volumes called Reporters and Online. Here are the reporters and online sites for the most recent cases of the major federal and state courts. An asterisk indicates an online fee-based site. The reporters online and in hardbound books, U.S. Supreme Court opinions. As noted earlier in the chapter, there are three main places to find and read U.S. Supreme Court cases. They are United States Reports, U.S., Unofficial Reporter, Supreme Court Reports, Lawyers Edition, 2nd Series, LED 2D, Unofficial Reporter. However, you also can find recent U.S. Supreme Court cases on its website, www.supremecourt.gov. The website has the unedited, annotated version of the court's opinion. There are no head notes in the cases posted on the U.S. Supreme Court website. What these cases do contain, however, is the official syllabus of the case. This is a summary of the court's decision, reasoning, and holding, and a good starting point to determine if the case will be relevant to your research assignment. More than likely, the first place to review a new U.S. Supreme Court decision is its own website. U.S. Courts of Appeals Opinion, Federal Reporter, 3D Series F.3D, an unofficial reporter. Like the U.S. Supreme Court, all the federal courts of appeals have individual websites that report their decisions, including their most recent ones. You can access federal court of appeals websites several ways. Go to www.uscourts.gov/court_locator/court websites.aspx. www.uscourts.gov/court_locator.aspx. Click an area of the map for the Court of Appeals covering your state. Click the link to that court to go to its website and find the link to the cases of that court on its website. You can also go to a search engine such as Google, Bing, or Yahoo and enter the name of the appeals court. A link to that court will be provided. For example, if you enter in the search box Third Circuit Court of Appeals, the result will be the website www.ca3.uscourts.gov. When you access that website, look for the section entitled Opinions. Other federal courts of appeals will have similar sections for their cases, especially their most recent cases. U.S. District Courts Opinions, Federal Supplement, 2nd Series F.SUPP.2D, an unofficial reporter. All the federal district courts have websites, but do not necessarily post their decisions there. Some post selective notable decisions, but you can access most district courts' decisions through www.govinfo.gov. Just locate the district court you are interested in reviewing through that site. www.uscourts.gov/court_locator/courtwebsites.aspx. www.uscourts.gov/court_locator.aspx. Click an area of the map for your state. Click the link to a district court to go to its website. Find the link to the cases of that court on its website. 9-10C. Online websites to locate cases from federal courts. There are a number of websites that publish cases and are readily available for review. Many are free. Those with asterisks are fee-based sites. They are www.findlaw.com, www.law.cornell.edu, scholar.google.com, select case law, www.justia.com/courts, www.plol.org, www.westlaw.com, asterisk, www.lexisnexis.com, asterisk, www.bna.com/Bloomberg Law, asterisk, www.fastcase.com, asterisk. 9-10D. Where can you find and read state cases? An asterisk indicates an online fee-based site. Earlier in the chapter, we discussed the national reporter system, including all the regional reporters. Go to the regional reporter that includes your state. Most states, especially the highest courts in a state, post their decisions online. Some have an extensive library, others do not. You will have to check your state court's web pages. More than likely, recent cases are posted and easily retrieved for review. 9-10E. Online resources for state cases. www.findlaw.com/casecode/state.html, law.justia.com, www.plol.org, www.westlaw.com, asterisk, www.lexisnexis.com, asterisk, www.bna.com/Bloomberg Law, asterisk, www.fastcase.com, asterisk. 9-10F. How do you find out if a case is still good law? Assume that you have a case that you want to rely on in your memorandum or other writing. Before you do so, you must find out whether the case has been appealed whether the case has been reversed, rejected, or canceled by a higher court in the same litigation, whether the case has been overruled, rejected, or canceled in a different litigation, whether the case has been found to be persuasive, has been followed by later courts. If you are reading a recent case by a lower court, you must determine whether the parties in the case appealed it to a higher court. If the case was affirmed on appeal, then it is still good law. The opposite is true, however, if the case was reversed on appeal. The opposite is true, however, if the case was reversed on appeal. Sometime later in a different litigation, the same court or a higher court may have overruled the case so that it no longer has value as precedent. Also, you need to know whether the case was cited by the courts. If many courts have cited the case and adopted its holding, then the value of the case as precedent is increased. The case can be said to be persuasive because other courts have agreed with it. How do you find out if a case has been appealed, reversed, overruled, or cited? You use a citator. A citator is a book or online service containing lists of citations that can A. help you assess the current validity of an opinion, statute, or other item, and B. give you leads to additional relevant materials. The major citators: Shepard's citations, available in paper volumes and online LexisNexis. When you use Shepard's citations to check the validity of a site, you are Shepardizing the site. The verb is Shepardize. It is important to pay close attention to the Shepard's signal indicators. That will tell you how a case was treated by the court you are reviewing. In Shepard's citators, a red warning sign indicates a case has had negative treatment or has been overruled. When you see the red stop sign next to a case you are Shepardizing, pause and rethink using the case. Learn the signals for the citator you are using. See Exhibit 9-6. For Shepard's signal indicators and treatments, KeyCite, available online on Westlaw. KeyCite is similar to Shepard's citators and uses a similar system, but with different terminology. KeyCite uses flags to indicate how a case was treated by a court. The flag you don't want to see is a red flag. That means the case is no longer good law. See Exhibit 9-7 for the KeyCite flag, signals, and treatment of cases. BCite, available online on Bloomberg Law. Similar to Shepard's and KeyCite, BCite uses a system of signals and analysis to indicate how a case was treated by a court. If you are using BCite as your citator, become familiar with its signals and terminology it uses in analyzing a case. Authority Check, available online on FastCase. Authority Check is FastCase's citator system. Negative case treatment will have a red flag next to it, but Authority Check has a unique feature called Bad Law Bot. That is an algorithm that finds negative information about the case. This citator is a bit different from traditional citators. Signal, red stop sign, red exclamation mark in a white circle, white Q in an orange square, yellow triangle, white plus sign in a green diamond, white A in a blue circle, white I in a blue circle, meaning red stop sign, warning, negative treatment indicated, indicates that citing references or history in the Shepard citation service contains strong negative history or treatment of your case, like for example overruled by or reversed. Red exclamation mark in a white circle, warning, indicates that citing references for a statute in the Shepard citation service contains strong negative treatment of the section, like for example the section may have been found to be unconstitutional or void. White Q in an orange square questioned Validity questioned by citing reference indicates that the citing references or history in the Shepherd's citation service contain treatment that questions the continuing validity or precedential value of your case because of intervening circumstances, including judicial or legislative overruling as mentioned in the citing reference. Yellow triangle, caution, possible negative treatment indicated, indicates that citing references or history in the Shepherd's citation service contain history or treatment that may have a significant negative impact on your case, like, for example, limited or criticized by. White plus sign in a green diamond, positive treatment indicated that citing references or history in the Shepherd's citation service contain history or treatment that has a positive impact on your case, like, for example, affirmed or followed by. White A in a blue circle, citing references with analysis available, indicates that citing references or history in the Shepherd's citation service contain treatment of your case that is neither positive or negative, like, for example, explained. White I in a blue circle, citation information available, indicates that citing references or history are available in Shepherd's citation service for your case, but the references do not have history or treatment analysis, like, for example, the references are law review citations. Source: University of Cincinnati. Exhibit 9-7, Westlaw Key Site Symbols. Yellow flag. Cases and administrative decisions, some negative treatment but not reversed or overruled. Statutes and regulations, proposed legislation or rule available, court decision has questioned validity or prior version received negative treatment from a court. Red flag. Cases and administrative decisions no longer good for at least one point of law. Statutes and regulations amended, repealed, superseded, or held unconstitutional or preempted in whole or in part. Research note: even if a case, statute, or regulation has a red flag, it does not mean that the entire authority is no longer good law. It may only be invalid for one or a few points of law, which is why it is extremely important that you actually read the case or legislation that invalidated your law to see which points are no longer good. Striped flag indicates a document has been appealed to the U.S. Court of Appeals or the U.S. Supreme Court, excluding appeals originating from agencies. Orange circle indicates that a document may no longer be good for at least one point of law based on its reliance on an overruled or otherwise invalid prior decision. Overruling risk indicator. Source: University of Cincinnati. Quick tip: most traditional law libraries have stopped their subscriptions to Shepherd citators. That means that the citators in the libraries are usually not up to date. Chances are you will not find recent Shepherd citators on a library shelf. That means you may need to use an online fee-based citator. 9-10G, Finding Statutes. Statutes are first published as slip laws, then in session law volumes, and finally, if they are of general public interest, in a statutory code. A slip law is a single act passed by the legislature and printed in a single pamphlet. A session law, sometimes called a statutes at large, is a statute passed by the legislature and printed in volumes that are organized by date chronologically rather than by subject matter. A statutory code is a collection of statutes organized by subject matter rather than by date. The most important session laws are eventually printed in a statutory code. 9-10H, Statutory Codes. There are official and unofficial statutory codes. An official statutory code is one published by the government or by a private company with special permission or authority from the government. An unofficial statutory code is one published by a private company without special permission or authority from the government. Most session laws are published by the government and therefore are official. Except for recently enacted statutes, researchers rarely consult session laws. Once a session law has been placed in a statutory code, it is much easier to find and read. The references below, therefore, are to the code versions of statutes. 9-10I. Where can you find and read federal statutes? Online and library statutory code volumes. United States Code, USC, official. United States Code, annotated, USCA, unofficial. United States Code Service, USCS, unofficial. Online statutory codes. An asterisk indicates an online fee-based site. www.gpo.gov. On homepage, scroll to free government information sources. Click GOV info and then click United States Code. uscode.house.gov. www.law.cornell.edu/uscode/text. Congress.gov. www.plol.org. law.justia.com. codes.lp.findlaw.com/US code. www.westlaw.com asterisk. www.lexisnexis.com asterisk. www.bna.com/Bloomberg Law asterisk. www.fastcase.com asterisk. 9-10J. Where can you find and read state statutes? Library statutory code volumes. Most law libraries will have a copy of the state code on their shelves. In addition, the main public non-law library in your city will probably have a copy. You need to determine if a library subscription to the code is kept current. Most libraries are less likely to have print volumes of a state's session laws. Researchers often rely on online sites, particularly the site of the legislature, for access to session laws. State legislature websites, www.ncsl.org. Enter State Legislature Directory in the search box. Online statutory codes, an asterisk, indicates an online fee-based site. In Google, Bing, or Yahoo, search AA statutes substituting your state for AA. Click the site that contains the current state code. www.findlaw.com/casecode/state.html. www.llsdc.org/state legislation. law.justia.com. www.plol.org. www.westlaw.com. www.lexisnexis.com. www.bna.com/Bloomberg Law. www.fastcase.com. 9-10K. How do you find out if a statute is still good law? Once you have a relevant statute, you need to find out if it has been repealed or amended by the legislature. You also need to find out whether the statute has been interpreted by the courts. Repeals or amendments of statutes. Many of the print volumes of statutory codes have pocket parts. Otherwise, they are often updated by separate supplement volumes. Suppose, for example, you are reading Statute 107B in the main volume of the code. To find out if there have been changes in Statute 107B, such as repeals or amendments, you would go to the pocket part of that volume, if any, and a supplement volume of the code, if any. In the pocket part and supplement volume, you would look up statute 107B. If you do not find this section, no changes have occurred since the date the pocket part or supplement was published. If statute 107B does appear, you will be told about changes and perhaps cases that have interpreted the section. Most current online versions of statutory codes do not need special update features. Repeals, amendments, or any other changes to the code are automatically included in the results of any search that you enter. However, determining whether a statute is still constitutional escaped an Arkansas attorney in Ward v. Dapper Dan Cleaners and Laundry Incorporated, 309 ARK 192828 SW2D 833 1992. Quick tip: after the statutory code section, there is a section providing the legislative history of the statute. This is an invaluable tool to use when doing statutory research. The legislative history tells you when changes were made to the statute, including amendments and repeals of sections as well. Order of the Court, a case study, Ward v. Dapper Dan Cleaners and Laundry Incorporated. Supreme Court of Arkansas 309 ARK 192828 SW2D 833 1992. Ward v. Dapper Dan Cleaners revolves around a request for a prejudgment attachment and the affidavits supporting that request. The Wards allegedly owed Dapper Dan money for performing cleaning services. Dapper Dan sued the Wards for the money allegedly owed. When Dapper Dan suspected the Wards were going to move property from the state, a prejudgment attachment was requested. The Wards' attorney immediately filed a motion to dismiss because 3 years earlier, the Arkansas Supreme Court had found that statute unconstitutional. The issues before the court were whether the trial court's finding that sanctions were not appropriate was an error and whether Rule 11 was violated. The Arkansas Supreme Court found that the trial court did not correctly apply the law. Here, the court unequivocally found that Dapper Dan's counsel failed to perform basic research by checking the pocket parts where it would have been discovered that the law was unconstitutional. Any reasonable inquiry, therefore, would have revealed that filing the prejudgment attachment request was improper. The trial court decision was reversed with the attorney being sanctioned. Discussion questions. Read Ward v. Dapper Dan Cleaners. What case was cited that found the Arkansas statute unconstitutional? What was the Arkansas Supreme Court's directive to the trial court? What is the significance of Rule 11, and why is it that Rule What is the significance of Rule 11, and why is that rule important? Court interpretations of statutes. Courts often interpret statutes. They might, for example, declare that a statute is invalid because it violates the Constitution. More commonly, a court will apply the statute to specific fact situations in dispute and thereby help to define the meaning of the statute. It is therefore important to be able to find cases, if any, that have interpreted a statute. The two major ways of doing so are notes of decisions and citators. Notes of decisions. Most statutory codes are annotated. An annotated statutory code is a collection of statutes organized by subject matter rather than by date. along with research references such as historical notes and summaries of court opinions that have interpreted the statutes. The summaries of court opinions are often called notes of decisions. These notes are printed under the text of the statute in the code. If, for example, you want to find out whether Statute 105B has been interpreted by the courts, you would go to the text of Statute 105B in the main volume of the code and in the pocket parts and supplemental volumes of the code, if any. Beneath the statute, you will find the notes of decisions, if any exist. Citators. We saw earlier that citators such as Shepard citations and KeyCite can be used to find out if a case has been reversed, overruled, or followed by other cases. The citator can serve a comparable function for statutes. The citator will tell you if a statute has been repealed, amended, or otherwise changed. The citator will also tell you if the statute has been declared unconstitutional or otherwise interpreted by court opinions. 9-10I. How do you find and read the legislative history of a statute? The legislative history of a statute is often used to help interpret the statute. For more on legal history, see Chapter 7. For example, when a committee of the legislature recommends the passage or defeat of a bill, it often writes a committee report that explains the purpose of the statute. Although this report and other documents of legislative history are not binding on a court interpreting the statute, they are often cited by the court to help it interpret and apply the meaning of the statute. The first place to look for legislative history is in the historical note that is printed after the statute in an annotated statutory code. Many statutes have a popular name, like for example, Civil Rights Act of 1964, in addition to their citation in codes, like for example, 42 U.S.C. Statute 1981. If you know the popular name of a statute, it can sometimes be helpful in the search for its legislative history. Other resources. Government law library websites. Go to the main law library site of the government that wrote the statute. At this site, look for links to legislative history of statutes. Call or email the library to ask for assistance in compiling the legislative history of your statute. Use the service Ask an Online Librarian mentioned earlier in the chapter. For federal statutes, Library of Congress, www.loc.gov/law. For state statutes, legislature. Try to contact the committee in the legislature that considered the statute. It might provide leads to the legislative history of that statute. The office of your representative or senator might be able to assist you. Depository library. Contact the depository library in your state to ask for leads. See the discussion of such libraries early in the chapter. Guides to legislative history. www.llsdc.org. Enter legislative history in the search box. www.llsdc.org/sourcebook. Fee-based services. Sites such as Westlaw and LexisNexis also provide extensive access to legislative histories. Also, another fee-based site is www.heinonline.com, which provides extensive legislative research on both federal and state statutes. The site www.nscl.com provides information on state laws, their status, and history. It often provides a 50-state composite of particular laws with state differences. 9-10M. Finding constitutional law. Constitutions are published in annotated statutory code, along with the statutes of the jurisdiction. In addition, you will find the text of the Constitution online. An asterisk indicates an online fee-based site. www.law.cornell.edu/constitution/overview. Constitution.org. www.archives.org. www.findlaw.com/casecode/state.html. www.plol.org, www.westlaw.com, www.lexisnexis.com, www.bna.com/Bloomberg Law, www.fastcase.com. 9-10N, Finding Administrative Law. As indicated when we covered citation, administrative regulations are usually published in a register, and then, if adopted, they are codified in an administrative code. An asterisk indicates an online fee-based site. Federal Register, fed.reg, www.ofr.gov, www.gpo.gov. On homepage, scroll to Free Government Information Sources, click GOV Info, and then click Federal Register. law.justia.com, plol.org, westlaw.com, lexisnexis.com, bna.com/Bloomberg Law, fastcase.com. Code of Federal Regulations, CFR, ecfr.gov, ofr.gov, gpo.gov. On homepage, scroll to Free Government Information Sources, click GOV Info, and then Code of Federal Regulations. law.justia.com, plol.org, westlaw.com, asterisk, lexisnexis.com, asterisk, bna.com/Bloomberg Law, asterisk, fastcase.com, asterisk. State registers. The name of the register for your state is listed in the back of the two main citation guides, Blue Book and ALWD, Guide to Legal Citation. Administrativerules.org, administrativerules.org/administrative rules, llsdc.org/state legislation, plol.org, westlaw.com, asterisk, lexisnexis.com, asterisk, bna.com/Bloomberg Law, asterisk, fastcase.com, asterisk. State codes of administrative regulations. The name of the administrative code for your state is listed in the back of the two citation guides, Blue Book and ALWD, Guide to Legal Citation. findlaw.com/casecode/state.html, administrativerules.org, administrativerules.org/administrative rules, plol.org, westlaw.com, lexisnexis.com, bna.com/Bloomberg Law, asterisk, fastcase.com, asterisk. Federal and state administrative decisions. Go to the website of the agency involved and look for links to its administrative decisions. Use the Ask an Online Librarian resource discussed earlier. Executive orders. Federal. On the site of the President, www.whitehouse.gov. Enter executive orders in the search box. Federal. www.archives.gov. State. On the site of the governor of your state, enter executive orders in the search box. Opinions of the Attorney General. Federal. Opinions of the Attorney General of the United States. www.justice.gov/OLC/opinions.htm. State. On the site of the Attorney General of your state, enter Attorney General opinion in the search box. 9-10O. Finding court rules, rules of court. An asterisk indicates an online fee-based site. Federal and state court rules. www.llrx.com/court rules. Go to the website of the federal or state court and look for the links to its court rules. plol.org, westlaw.com, fee-based site, lexisnexis.com, fee-based site, bna.com/Bloomberg Law, fee-based site, fastcase.com is a fee-based site. Federal court rules. The federal court rules can be found at www.uscourts.gov. For specific local rules, For the federal courts, check the court's website. Local rules are rules that are specific to a particular court and only apply to that court. Additionally, many judges have specific rules for their courts that supplement the federal court rules. Check the website for the specific court and judge to determine whether special rules apply to that judge's court. See also online sites noted in the prior sections. State court rules. Similar to the federal rules, state court rules are located on court websites. Also check the same listed sites in this section for the state court rules, both free and fee-based. Many state courts have local rules of court similar to the federal courts. They need to be checked when doing research, especially when preparing legal documents for that court. Quick tip: whether practicing in a federal or state court, judges have rules just for their court. If your jurisdiction has 5 federal district courts, it is likely that there will be 5 different rules in practicing in the court. Don't get court filings rejected for failure to comply with a specific court's rules. Do your research and check local court rules for practice and procedure in that court. 9-10P, Finding Local Law. An asterisk indicates an online fee-based site. General, go to the website of the city, county, or town and look for links to its laws and regulations. Westlaw.com, online fee-based site. LexisNexis.com, online fee-based site. Municipal codes. Many states' online library depositories have information on municipal codes along with legislative history. Another good source of local laws are the online law libraries for that state. For example, Rutgers University's online library has municipal codes and legislative histories for New Jersey municipalities. The City of Philadelphia has a website for the City Council's legislative actions and history at phila.legistar.com. A general online search will get you started if you need to research codes and legislative histories for cities, towns, and municipalities. municode.com/library, findlaw.com/11stategov/municipal.html, https://codelibrary.amlegal.com. 9-10Q, Finding International Law. An asterisk indicates an online fee-based site. U.S. treaties enforce state.gov, laws of the United Nations, un.org/en/law, guides to international law, ICJ-CIJ.org. The International Court of Justice provides information on international case law. Findlaw.com, https://NYUlaw.libguides.com, library.law.yale.edu, https://eisil.net, westlaw.com, online fee-based site. LexisNexis.com is a online fee-based site. BNA.com/Bloomberg Law is a online fee-based site. 9-11, Westlaw and LexisNexis. As we have seen in this chapter and will see in chapter 13, a great deal of legal and factual information is available online for free. Much of this information is also available for a fee from the major commercial online services. Westlaw and LexisNexis, affectionately referred to together as Wexis, a non-legal term, and the most recent large service, Bloomberg Law. These giants, however, are unlikely to go out of business because of competition from the free resources online. Westlaw, LexisNexis, and Bloomberg Law spend a great deal of editorial time and money ensuring the accuracy and currentness of the information they make available. No comparable control mechanisms exist for much of the free information found online. The reliability of free information is increasing, particularly at government-run sites that provide access to the government's own statutes, cases, court rules, and administrative regulations. But these free sites are not yet able on their own to satisfy the legal community's need for accurate and current online legal information. Westlaw, LexisNexis, Bloomberg, and now Fastcase will continue to play major roles in online research. Most law firms have some type of subscription to a fee-based legal research site. It is important to have a general understanding of the dynamics of those sites. Let's take a closer look at the two main providers in the field of fee-based legal research, Westlaw and LexisNexis. Westlaw and its current version, Westlaw Precision, are products of Thomson Reuters, www.westlaw.com. LexisNexis and its current version, Lexis Advance, are products of Reed Elsevier, LexisNexis.com. 9-11A Scope of Westlaw and LexisNexis. Westlaw and LexisNexis allows you to search the full text of primary authority, such as constitutions, statutes, administrative regulations, administrative decisions, court rules, treaties, and local law. You can also conduct full-text searches of secondary authority, such as legal periodicals, encyclopedias, treatises, and newsletters. In addition, Westlaw and LexisNexis give you access to a large variety of factual information, such as the following: the status of pending lawsuits in federal, state, and local courts, records of judgments in bankruptcy courts, other federal courts, state courts, county courts, and other local courts. Statistics on jury awards for specific kinds of injuries, mechanics, lien filings, Uniform Commercial Code, UCC filings, business and personal addresses, names of key personnel in particular companies, like, for example, officers, members of the board of directors, major properties, like, for example, land, stock, commercial equipment, owned by particular individuals and businesses, financial status of companies based on sales data, stock market prices, and property holdings, financial details and status of proposed mergers and acquisitions, chain of title records on specific property, medical research, like, for example, side effects of particular drugs, news stories on particular topics, companies or individuals in newspapers and other media throughout the world, birth and death records, social science studies. This overview is not meant to suggest that the contents of Westlaw and LexisNexis are identical. Each claims to outdo the other in special features, ease of use, comprehensiveness, and diversity of coverage. Yet, as demonstrated by the above overview, the coverage in both systems is substantially similar. Adding to the list of product coverage, with the advent of artificial intelligence, AI, both companies are bringing forth new products which have AI components. 9-11B Searches on Westlaw and LexisNexis. There are two main methods of phrasing search queries on Westlaw and LexisNexis. 1. Natural language, and 2. Terms and connectors. These two methods also exist on many of the free research sites online. Keep in mind, however, that each research site can establish its own way of phrasing queries. You will note similarities, but watch for differences among the various sites. Natural language searching uses everyday speech to phrase questions. Both LexisNexis and Westlaw use the natural language method. Here are some examples of natural language questions that can be posed in both services. What is the statute of limitations for embezzlement in Virginia? When can a minor enter a contract in California? When can strict liability be imposed for harm caused by smoking in Illinois? Type the query in the same way that you would ask a question in plain English to a friend or colleague. Such natural language queries or questions can also be used in general search engines such as Google, Bing, and Yahoo. Terms and connectors searching. A more precise method of phrasing queries on Westlaw and LexisNexis uses terms and connectors. This method is based on rules of search logic referred to as Boolean logic. In a terms and connector search, you specify relationships between terms in a search query in order to identify the documents you want included in or excluded from the search. The relationships are indicated by powerful connectors such as and or, and not. Here's an example of a terms and connectors search in Westlaw: marijuana and arrest. Let us assume you want to use this query to search for opinions of your state courts. The query tells the computer to find every opinion in the database that contains the term marijuana anywhere in the opinion, and that also contains the term arrest anywhere in the opinion. The terms being searched are marijuana and arrest. The and connector, phrased in Westlaw by using the word and or by using an ampersand, and tells the computer that you want to be given every opinion in the database that contains both terms. Of course, if your search query consists of a single term, you do not need connectors. You are simply telling the computer to find every document that contains that term. Single term searches, however, are usually unproductive because they produce too many documents. This is also true of general search engines such as Google, Bing, or Yahoo. Suppose, for example, you entered the following search query in Westlaw. This query would probably identify hundreds of thousands of documents because of the large number of documents that contain this term. In fact, Westlaw will quickly flash a message on the screen telling you to change your query because the one you are using is likely to generate too many documents. Hence, unless your single term is a unique legal term, like for example, asportation, or an unusual surname, like for example, Wazinski, your query should include more than one term. When it does, connectors are needed to state the relationship between the terms. Although in the following discussion we will use some single-term queries for purposes of highlighting a particular search technique, keep in mind that multiple-term searches are usually more effective than single-term searches. Universal character, asterisk, in Westlaw and LexisNexis. Both Westlaw and LexisNexis use the asterisk as a universal character that stands for any single character, such as a letter of the alphabet. A universal character is useful when you are not sure of the spelling of a term you want to search. For example, in the drug arrest example we just examined, suppose you were not sure whether the drug was spelled marijuana or marijuana. You could enter the search this way: MARI UANA and arrest. This query will find any document that spells the term as marijuana, etc. Because the asterisk stands for any single letter or character, it is called the universal character. You are not limited to one universal character per term. The following query, interstate, will find every document that contains the term interstate anywhere in the document and every document that contains the term intrastate anywhere in the document. Similarly, the query S*** holder will find every document that contains the term shareholder anywhere in the document, and every document that contains term stockholder anywhere in the document, and every document that contains the term stakeholder anywhere in the document. The query F***NST***N will find any document that contains words with the following spellings or misspellings anywhere in the document: Feinstein, and Feinstein. Root expander, ! in Westlaw and LexisNexis. Most Westlaw and LexisNexis use the exclamation point as a root expander. When added to the root of any term, the exclamation point acts as a substitute for one or more characters. The root expander and the universal character are examples of wildcards, which are special characters that can be used to represent one or more characters in a search query. The root expander in Westlaw and LexisNexis is inserted at the end of a term or at the end of a fragment of a term in order to broaden the scope of the search. If your query is LITIG exclamation point, you will find every document that contains any of the following terms anywhere in the document: litigable, litigate, litigated, litigating, litigation, litigator, litigus, and litigousness. The root expander is quite powerful and can be overused. The query tax exclamation point will find every document that contains any of the following terms anywhere in the document: tax, taxability, taxable, taxation, taxational, taxer, taxco, taxing, taxes, tax deductible, tax exempt, tax free, taxi, taxicab, taxidermy, taxidermist, taxied, taximeter, taximetrics, taxing, taxes, taxiway, taxman, taxold, taxon, taxonomist, taxonomy, taxpayer, tax shelter, taxi, and taxiing. Hence, if you use tax exclamation point as a search query in a large database, you are likely to find many documents that are irrelevant to your research problem. Plurals in Westlaw and LexisNexis. In Westlaw and LexisNexis searches, it is not necessary to use the universal character or the root expander to search for the plural of a term. The query prosecutor will give you every document that contains the term prosecutor or the term prosecutors anywhere in the document. The same is true of irregular plurals. The query child will give you every document that contains the term child or the term children anywhere in the document. The query memorandum will give you every document that contains the term memoranda or the term memorandums anywhere in the document. Entering the singular form of a term will automatically result in a search for the plural form of that term also. Thus far, we have examined the universal character asterisk and root expander exclamation point. Again, keep in mind that this discussion applies only to Westlaw and LexisNexis. When you are searching in other search resources, like for example on general search engines, you may find that these notations, asterisk and exclamation point, serve related but different functions. Tutorials to understand how specific queries are phrased in Westlaw and LexisNexis. Check available tutorials online. These tutorials are excellent tools for learning how to maneuver your way through Westlaw or LexisNexis. YouTube is a good source for tutorials as well. Quick tip: both Westlaw and LexisNexis provide for searches to be limited by a jurisdiction. To limit a search by state, open the box entitled Jurisdiction and check the box for the specific jurisdiction for your inquiry. Otherwise, you will get a search that includes all states and all federal jurisdictions. Narrowing your search by jurisdiction is one of the keys to efficient legal research. 9-11C, Citators in Westlaw and LexisNexis. As we have seen, a citator helps you assess the current validity of a law, like for example opinion, statute, and gives you leads to other relevant materials. The online citator in Westlaw is called KeyCite. The online citator in LexisNexis is called Shepard's. The latter is the electronic version of the paper volumes called Shepard's Citations. Suppose, for example, you want to know whether a particular court opinion is still good law. Has the opinion been reversed on appeal? Have any other courts followed it or criticized it? Has the opinion been overruled? One of the ways to answer such questions is by using the online citators of Westlaw and LexisNexis. As noted earlier, Both systems use colored alert signals to tell users about changes in court opinions, statute, or other authority they are checking in the citator. 9-11D Alternative Fee-Based Services. As indicated, the giant services Westlaw, LexisNexis, and Bloomberg Law are expensive. Less expensive alternatives include www.casemaker.us, Casemaker, www.fastcase.com, Fastcase. 9-11E Summary of Terminology and Legal. Summary of Terminology of Legal Research. Throughout this chapter, we have explored many of the legal research sources you will encounter online or in a physical law library. Mastering the terminology and many of the shorthand abbreviations used by legal professionals is critical to working in a legal environment. Exhibit 9-8 contains a summary list of basic legal research terms that you have been introduced to in this chapter, and you should now have some familiarity with. They are defined in this chapter, in other chapters, and in the glossary. As the chapter has shown, these terms in Exhibit 9-8 are the foundation for all of legal research. Exhibit 9-9 contains a short summary list of some of the major abbreviations that you should know and will encounter as you work with the legal resources discussed in this chapter. Place both lists in your portfolio binder as a guide and quick reminder for future assignments. Exhibit 9-8 Basic Legal Research Terminology. A guide. Definitions. Some of the terms are defined in this chapter, others are defined in Chapter 7 and 8, and in the glossary at the end of the book. For online definitions, type define. Include the colon, the word or phrase you want to define, plus the word law. For example, if you wanted an online definition of mandatory authority, enter this search in Google, Bing, or Yahoo. Define mandatory authority law. Use quotation marks for phrases. Act, administrative decision, administrative regulation, advance sheet, ALR index, American Digest System, American Jurisprudence 2D, American Law Reports, ALR, analogous, annotated, annotation, appellant, appellee, Attorney General opinion, authority, bill, black letter law, Bloomberg law, caption, cartwheel, case in point, character, citation, cite, citator, cite checking, code, common law, constitution, corpus, juris secundum, court rules, rules of court, descriptive word index, DWI, desk book, dictum, digest, enacted law, equity, executive order, Federal Depository Library, Google Scholar, head note, historical note, holding, horn, book, ID, infra, key number, key site, law review, law journal, legal encyclopedia, legal periodical, legal treatise, legislation, legislative history, Lexis Advance, LexisNexis, mandatory authority, loose leaf service, national reporter system, on all fours, opinion, case, ordinance, parallel site, per curiam, persuasive authority, pocket part, practice guide, precedent, primary authority, public domain citation, regional reporter, register, reported, reports, restatement, search engine, secondary authority, series, session law, shepherdize, slip law, slip opinion, stare, star paging, statute, statutes at large, supra, table of authorities, TOA, terms and connectors, treaty, uniform laws, unpublished opinion, Westlaw next, Westlaw precision. Exhibit 9-9, common abbreviations used in legal research. A or ANN annotated, A.3D Atlantic Reporter 3rd Series, ALR American Law Reports, ALR 6th American Law Reports 6th Series, AMJUR 2D American Jurisprudence 2D, ART Article, BR Bankruptcy Reporter, C Chapter, CAL RPTR 3D California Reporter 3rd Series, CERT Certiorari, CFR Code of Federal Regulations, CJS Corpus Juris Secundum, CH Chapter, CTAPP Court of Appeals F3D Federal Reporter 3rd Series, F 4th Federal Reporter 4th Series, Fed RCIV PROC or FRCP Federal Rules of Civil Procedure, Fed REG Federal Register FEDR EVID or FRE Federal Rules of Evidence, FSUPP 2D Federal Supplement 2nd Series, FSUP 3D Federal Supplement 3rd Series, LED 2D United States Reports Lawyers Edition 2nd Series, LREV Law Review NE2D Northeastern Reporter 2nd Series, NW2D Northwestern Reporter 2nd Series, OP Opinion P3D Pacific Reporter 3rd Series, S or Section SCT Supreme Court Reporter, SE2D Southeastern Reporter 2nd Series, SO2D Southern Reporter 2nd Series, SO3D Southern Reporter 3rd Series, SW2D Southwestern Reporter 2nd Series, SW3D Southwestern Reporter 3rd Series, TC U.S. Tax Court, U.S. United States Reports, USC United States Code, USCA United States Code Annotated. (9-12) Research, Self-Audit, and Roadmap. The checklist in Exhibit 9-10 is designed to help you achieve the comprehensiveness that is essential to all aspects of legal research. Fill out a separate research self-audit for each issue you research. Start by summarizing the issue in the box at the top of the checklist. The checklist serves as a reminder to make sure that you have covered all bases. Note that Part IV tells you to keep a research log. You not only want to be comprehensive, but also you want to be able to tell others and remind yourself what steps you took along the way. Additionally, Exhibit 9-11 provides a general roadmap to follow when beginning a legal research project. Be methodical and deliberate in preparing to perform legal research. Analyze what you want to do and think about what you want to accomplish. Just don't jump. Have a plan and work that plan. Remember, the more you do it, the easier it will become. Exhibit 9-10, Research Self-Audit, Issue Number. Briefly state issue researched. 1. What I have checked. Legal materials. A. Primary authority, charter, federal administrative decisions, federal administrative regulations, federal constitution, federal court opinions, federal court rules, federal statutes, international law, local administrative decisions, local administrative regulations, local court rules, ordinances, state administrative decisions, state administrative regulations, state constitution, state court opinions, state court rules, state statutes. B. Secondary authority and finding aids, ALR annotations, digests, legal encyclopedias, legal newsletters, legal periodicals, legal treatises, practice guides and form books, words and phrases, legal dictionary. What I have checked: non-legal materials. When relevant to the research problem, I have checked non-legal literature in the areas of accounting, biology, business management, chemistry, medicine, psychiatry, psychology, statistics, sociology. 3. What I intend to rely on in my research memo. For every primary authority I intend to use, I have used online citators to determine whether it is still valid, e.g., for example, Shepard's key cite. If available, use paper citators to determine whether it is still valid, like, for example, Shepard's citations. Checked other standard updating features, like, for example, pocket parts, supplement pamphlets, history tables, online sources. IV research log. For each paper volume or online resource, free or fee-based online sites that I checked, I have made the following brief notations in my research notebook or log: the name or address of the resource, the major words and phrases I have checked in the resource, the library used for this resource, if more than one, the people consulted for guidance, leads before completion, people with whom I have shared my research strategy to determine whether they think I have omitted something. Ask a librarian, law clerk, law librarian, experienced paralegal, experts, other attorneys in office, supervisor, other. Exhibit 9-11, Legal Research Roadmap, Research Assignment Plan. Determine the secondary sources to be consulted: legal encyclopedias, CJS, and AMJUR, ALR digests, general or state specific, Google, Bing, or Yahoo general search. Review secondary sources. Review the secondary sources and write down relevant words and phrases. Continue review of secondary sources and write down possible, applicable primary sources such as cases, statutes, etc. Write down concepts that may be helpful in a search. Retrieve the primary sources identified for review. Review the primary sources for relevancy. Brief cases if necessary, or review statute, constitution, or administrative rule or regulation. Narrow down applicable primary sources. Shepardize or key cite the primary sources chosen. Determine how cases were treated by the courts. Make sure the cases are still good law. Analyze the primary sources. Analyze the relationship of primary sources to facts in your assignment. Prepare the assignment, such as a memorandum of law. As a final look at this chapter's information, let's use our facts from the beginning of the chapter and work through a legal research plan. Step 1. Write down words and phrases that may apply to our facts. We already worked through some words and phrases from earlier in the chapter. Step 2. Choose some secondary sources to assist in learning about the area of law that may apply to your assignment. Start with a general Google search or locate information from a legal encyclopedia on the topic, such as CJS or AMJUR. You can either review a general encyclopedia or state-specific encyclopedia. Step 3. From your secondary sources, write down relevant statutes or cases that appear to apply to the facts of the assignment. Write down any other primary sources that may apply as well, such as a constitutional provision or rules or regulation. From this, you should be able to determine whether your issue is mainly a federal or state issue. Here is where your research will be state specific. Based on what your secondary sources reveal, make your list of primary sources you want to check. Step 4. Begin reviewing your primary sources of law to determine what may apply to your assignment. Remember to keep track of your process. Step 5. At this point, you may consider preparing case briefs for those cases that may apply and support your assignment. Chances are that you will be reviewing a number of cases and statutes. It is the rare occasion when you will have just 1 or 2 cases that apply to a research assignment. Step 6. Before formulating your analysis and issues in preparation of your memorandum of law, use a citator to check to see if the law you have chosen is still a good law, or if a case has had negative treatment. Step 7. Begin drafting your memorandum of law. As we will learn in the next chapter, you must draft, edit, redraft, and edit some more before you have a final product. Real-world perspectives, on-the-job observations. Paralegals must be resourceful in locating information, as we see in our next paralegal observations. An industrious paralegal found the answer to a legal research question by performing a general Google search. The results were helpful to a case being worked. Recently, a paralegal, Tina R., described an incident involving a tax question that Tina and their supervising attorney were discussing. The attorney did not know the answer, so they called a CPA friend. The CPA did not know the answer either, but while the attorney and CPA were on the phone discussing the question, Tina did a Google search of the IRS website and found the answer. "Wow, Tina's really good," the CPA said to the attorney. Our next paralegal observation is from the labor law arena, where a paralegal details some of the research performed when working on cases. Here, the paralegal is performing background information as well as preparing documents for cases. The paralegal stated, "In the labor law area, I was responsible for doing background research, preparing witnesses, and drafting arbitration briefs. I also assisted with the drafting of revised language during contract negotiations with unions." Die bold, a paralegal of another kind. 16 Facts and Findings, 38 NALA. Chapter Review 9-13A. Chapter Summary. Introduction. The law is changing every day. The only dependable way to find out about all of these changes is through legal research. Research skills will take time and determination to develop. Performing legal research online or in the traditional law library, that is the question. 1. The major categories of law sites online are fee-based private sites, free government sites, and free private sites. The first 2 categories are the most reliable for providing the full text of primary authority. All sites, however, are potentially useful for providing links to primary authority and may help with background research. 2. Google and Wikipedia may be good places to start a general search. Each will provide basic information on a myriad of subjects, but do not use either Google or Wikipedia as your main source of research. Go to the primary sources of law for your legal assignments. Finding traditional law libraries. Law libraries are available in traditional brick and mortar buildings online. A federal depository library is a public or private library that receives free federal government publications, like, for example, the Statutes of Congress, to which it must allow access by the general public without cost. In some states, there is a comparable program for state government publications. Ask an online librarian. Many libraries have an Ask a Librarian program. These programs are usually utilized through email and cannot give legal advice. They are a general research tool that can provide good leads. Cartwheel. The cartwheel is a technique designed to help you think of a large variety of words and phrases to check in search engines and indexes. It is a technique used in addition to descriptive words and TAPP. Kinds of authority. 1. The two major categories of authority are primary authority and secondary authority. Primary authority is any law written by one of the three branches of government. Primary authority can be mandatory or persuasive. 2. The Constitution is the highest authority. Statutes are higher in authority than regulations, and the common law. The major categories of secondary authority are legal encyclopedias, annotations, legal periodicals, legal treatises, practice guides, loose leaf services, and legal dictionaries. Citation. 1. A citation is a reference to any authority printed on paper or stored in a computer database that will allow you to locate the authority. Some courts require specific citation formats in documents submitted to that court. 2. Citation rules and manuals tell you what to abbreviate in the citation, where spaces and commas must be inserted, in what order the information in the citation must be provided, when to include a parallel cite, etc. A parallel cite is an additional citation where you can find the same written material in the library or online. 3. A public domain citation is a citation that is not dependent on the volume and page number of a reporter. It is both medium neutral, meaning that it can be read in a paper volume or online, and vendor neutral, meaning that it does not contain volume, page, or other identifying information created by a particular vendor, such as a commercial publisher. Cite checking. Cite checking is examining citations in a document to determine their accuracy, such as whether the format of the citation is correct, whether a parallel cite is needed, whether quoted material is accurately quoted, and whether the cited law is still valid. The first level of legal research. The three levels of research are background research, specific research, and validation research. Some of the main sources of background research include legal dictionaries, general search engines, legal encyclopedias, legal periodicals, and administrative agencies, and legislative committees. Finding the law. 1. Case law. The goal when researching an assignment is to find applicable laws that are analogous to the facts of the assignment. To do this, start with a digest or ALR annotations for a broad overview of the law. Cases are found in reporters, both online and in traditional libraries. 2. Once a case is located that may be relevant to your research, you must make sure it is still a good law. That is done through a citator. A citator is a book or online service containing lists of citations that can A. help you assess the current validity of an opinion, statute, or other item. And B, give you leads to additional relevant materials. 3. The two main citators are Shepard's and KeyCite. Both provide a signal system and treatment of the case so you can determine whether to use the case in your assignment. 4. Statutes. Statutes are first published as slip laws, then in session law, and finally in the statutory codes. Federal laws are located in the United States Code with state statutes found in that state's statutory codes. States have different names for their statutory codes. As with cases, statutory laws must be validated through a citator to determine whether there have been any changes to the law, such as amendments or repeals. 5. Constitutional law. The constitutions can be found in statutory codes at both the federal and state level. Annotations and cases can be found on many of the fee-based sites, which analyze the constitutional provisions cited. 6. Administrative law. Administrative regulations are codified in administrative codes. Federal administrative regulations are found in the Federal Register and codified in the Code of Federal Regulations. There are state equivalents for both. 7. Court rules. Rules of court. Court rules can be found online on the court's website, fee-based research sites, and on general legal library sites. For federal rules, check the federal courts, and for the state rules, check the state court websites. Westlaw and LexisNexis. 1. The main fee-based legal research online services are Westlaw and LexisNexis. Another major online service is Bloomberg Law. A smaller online service is FastCase. All provide fee-based legal research services. 2. Both Westlaw and LexisNexis use natural language and terms and connectors searching techniques to refine legal research. Both root expanders and universal characters can be used on each site. 3. The major citators include Shepard's Citations, LexisNexis, and KeyCite Westlaw. Both provide for means to check whether the primary sources found are still good law. Using a citator is an essential step in the legal research process. Summary of legal research terminology. Mastering legal terminology is important to the legal profession, including legal research. As a paralegal, you should learn and understand the new legal terms that will be introduced. Research self-audit and legal research roadmap. Chapter Review 9-13B. Key terms. Uniform Electronic Legal Material Act, UELMA. Federal Depository Library, Cartwheel. Derogation. Legal encyclopedias, legal periodicals, legal treatises, practice guides, legal dictionary, pinpoint site, codified, restatement, site checking, short form citation, terms of art, descriptive word index, ALR index, overruled, Shepardized, slip law, session law, statutory code, pocket parts, annotated statutory code, notes of decisions, committee report, historical note, popular name, natural language, terms and connectors, universal character, root expander, wild cards. Chapter Review 9-13C. Review questions. 1. What are the main categories of legal sites online, and what is the reliability of these categories? 2. What is the cartwheel and what are its 8 categories? 3. What is the distinction between mandatory and persuasive authority? List the types of mandatory authority. 4. What is the hierarchy of authority among primary authorities? 5. What are the main categories of secondary authority? 6. What is a citation and what are the 2 major citation guides? 7. Define parallel cite, pinpoint cite, and public domain cite. 8. Name 3 reporters for opinions of the U.S. Supreme Court and state whether each is official or unofficial. 9. Name 3 codes that contain the statutes of Congress and state whether each is official or unofficial. 10. What is cite checking? 11. What are the functions of the 3 levels of legal research? 12. How do digests and ALR annotations serve as case finders? 13. What is the function of a citator? Name 4 citators. 14. What are slip laws, session laws, and statutory codes? 15. What is the distinction between natural language and terms and connectors searching and using a fee-based service? Chapter Review 9-13D Assignments Critical Analysis 9.1 A. Computers can perform functions much faster than humans can. Discuss whether it is therefore true that traditional legal research should not be used when computer research is available. B. Artificial intelligence, AI, is now being used in legal research. What are the pros and cons in using this technology in legal research? Are there any ethical issues that AI presents? If so, identify those issues and discuss the implications. Projects 9.2. Define all the research terms in Exhibit 9-8. Use the definitions in Chapters 7, 8, and 9, and the glossary at the end of this text. 9.3. Go to the website of your local public library. Make a list of available free databases that might be of assistance to a paralegal doing factual or legal research. Describe each database and state how it might be helpful to the paralegal. Chapter Review 9-13E Core Skills Assignments, Core Skill Research. 9.4 Using the guidelines of Exhibit 9-2. Cartwheel. The following words or phrases: A. Paralegal. B. Cruelty. C. Support. D. Paternity. 9.5 In your state and in any 2 others, what is the minimum age to enter a valid marriage without the consent of parents or guardians? Cite and quote from the primary authority you used to answer this question. 9.6 Cite and quote from the primary authority of your state that answers the following questions. A. Can a doctor assist a patient to commit suicide? B. Can a church be forced to pay taxes on profits from its bingo games? C. Can a local government use its zoning laws to try to close a bar that features topless dancers? D. Can a minor daughter challenge the validity of a deceased parent's will that leaves everything to the parent's pet cat? E. Can a burglar bring a civil suit against a homeowner for injuries received when the burglar fell because of a defective floor in the house being burglarized? F. Can a husband be prosecuted for raping his wife? G. Can a patient prevent his doctor from telling the patient's health insurance company about the patient's AIDS status? 9.7 Here are 5 separate queries. if they were performed in either Westlaw or LexisNexis, what terms and documents would they find? 1. Para. 2. Assign. 3. Crim. 4. Legis. 5. E asterisk 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 E. Core skill writing. 9.8. Write a memorandum of law based on the facts of one of the problems in assignment 9.6. For the format of the memorandum, see Chapter 8. You can make up additional facts, like, for example, the names of the parties and your supervisor, and more details about the questions asked. Core skill, ethics. 9.9. The attorney for whom you work has a case before a court in your state. The attorney asks the court to award the client triple damages for the kind of injury caused by the opposing party. There is, however, a recent court opinion in the state that held that parties are not eligible for triple damages in this kind of case. The attorney does not tell the judge about this opinion, and the opposing attorney is unaware of it because of sloppy legal research. What ethical rule has the attorney violated by failing to tell the judge about the opinion? Cite and quote from the specific ethics rule that applies in your state. See the discussion in Chapter 6 on the duty to disclose contrary authority. To find the ethics code in your state, see Appendix C. Core skill, computers. 9.10. In Google, Bing, or Yahoo search, compare fee legal databases research sites that cover both federal and state law. Write a memorandum in which you compare any 3 fee-based legal research services. The comparisons should cover strengths, weaknesses, and costs of the 3. For each of the 3, you must cite at least 2 websites. In the computer terminology in the law CTL notebook you started in Chapter 1, enter any new terms that you learned by doing this assignment. Core skill collaboration. 9.11. This chapter mentions several free and fee-based sites on which you can find the full text of primary authority, not just links to the laws. Your instructor will assign you 1 free and 1 fee-based full-text site. Answer the following questions about your 2 sites. A. What is the website? B. What are its major features? C. Does the site have a citator? If so, how does it work? Email your answers to each member of your class. Incorporate their answers into a memorandum that covers your 2 sites and the sites assigned to other students. The job search. 9.12. Create a blog on the Google Blogspot through the blogger.com or on wordpress.com that can be included on your resume. Call it YY's Legal Research Links for AA Law. For AA, substitute the name of your state. For YY, substitute your name or a made-up name. Use any of these sites from this chapter as leads to law in your state. The entries on your blog should include both paper and online resources. For every entry, include a 1-sentence description of what you are including. Your blog must cite a minimum of 5 paper volumes and 10 websites. Try, however, to include more than the minimum. Your entries should include the Constitution, statutes, court opinions, administrative regulations, administrative decisions, and local laws of your state. You can also include links to secondary authorities on the law of your state. Here are resources on setting up a blog. Instructions for creating a blog, click on blogger.com or wordpress.com and follow the prompts. Tutorial on creating a blog. On YouTube, type this search, Blogspot tutorial. Chapter Review 9-13F. Portfolio Binder Assignment. 1. We are going to add some facts to our introductory fact pattern so we can create a specific research plan based on your state law. What we have learned from our initial conference with the client is that the client, was sleeping with the keys in the car. The client was parked at the time the police approached. The client does not know whether the place where the car was parked was a public or private area. The client was not doing anything suspicious other than sleeping. The client was not offered a breathalyzer test or field sobriety test, at least not that they can remember. Prepare your research plan based on these facts. Identify the words and phrases used and the secondary sources and steps you use in finding your sources. 2. List the cases, statutes, or constitutional provisions you found that you believe would be applicable based upon your jurisdiction's law. 3. Brief the cases and summarize the statutory sections that you may have found. 4. Prepare an outline of a memorandum of law that you would present to your supervising attorney. Place this in your portfolio binder. Note, we will use this assignment as a foundation for your next assignment in Chapter 10. Uniform Electronic Legal Material Act, a statute that provides a method of letting users of government sites know that the law contained on these sites is authentic. Federal Depository Library, a public or private library that receives free federal government publications, like for example the Statutes of Congress, to which it must allow access by the general public without cost. In some states, there is a comparable program for state government publications. Cartwheel, a technique designed to help you think of a large variety of words and phrases to check in online search engines and in book indexes. Derogation, a partial repeal or abolishment of a law. Legal encyclopedias, a multi-volume set of books that summarizes almost every important legal topic. Legal periodicals, a pamphlet issued at regular intervals, like for example, quarterly, containing articles and notes on legal topics. Later, the pamphlets are often bound. Legal treatises, a book written by a private individual or by a public individual writing as a private citizen that provides an overview, summary, or commentary on a legal topic. Practice guides, a legal treatise that provides practical advice on an aspect of the practice of law, often including standard forms and checklists. Legal dictionary, An alphabetical list of legal words and phrases that are defined. Pinpoint cite. A reference to specific material within a document, like for example, a quote, in addition to the citation of the entire document, also called a jump cite. Codified. To arrange laws or rules in a systemic order, usually by subject matter, regardless of when the laws or rules were enacted. The noun is codification. Restatement. A special legal treatise of the American Law Institute that states the law and indicates changes in the law that the Institute would like to see implemented. Cite checking. Examining citations in a document to determine their accuracy, such as whether the format of the citation is correct, whether a parallel cite is needed, whether quoted material is accurately quoted, and whether the cited law is still valid. Short form citation. An abbreviated citation format of an authority for which you have already provided a complete citation earlier in the document. Terms of art. Words or phrases that have a special or technical meaning. Descriptive Word Index, DWI. The main index to the digests of West, Thomson Reuters. The index will lead you to key numbers, which is the heart of the organization system used by the digests to find case law. ALR Index. The main index to annotations within the volumes of American law reports. Overruled. To reject or cancel a holding in an earlier opinion by rendering an opposite decision on the same question of law in a different litigation. See glossary for an additional meaning. Shepardize. To use Shepard's citations in book form or online to obtain validation and other data on a case, statute, or other document you are Shepardizing. Slip law. A single act passed by the legislature and printed in a single pamphlet. Session law. A statute passed by the legislature and printed in volumes that are organized by date, chronologically, rather than by subject matter, sometimes called statutes at large. Statutory code. A collection of statutes organized by subject matter rather than by date. An official statutory code is one published by the government or by a private company with special permission or authority from the government. An unofficial statutory code is one published by a private company without special permission or authority from the government. Pocket parts. A pamphlet inserted into a small pocket, built into the inside, back, and occasionally front cover of a hardcover volume. The pamphlet contains text that supplements or updates the material in the hardcover volume. Annotated. To provide notes or commentary, a text is annotated if such notes and commentary are provided along with the text. Annotated statutory code. A collection of statutes organized by subject matter rather than by date, along with research references such as historical notes and summaries of court opinions, notes of decision, that have interpreted the statutes. Notes of decisions. Summaries of opinions that have interpreted a statute, usually printed beneath the text of the statute and annotated statutory codes. Committee report. A summary of a bill and a statement by the committee of the reasons for and against its enactment by the legislature. Historical note. Information on the legislative history of a statute printed after the text of the statute. Popular name. A phrase or short title identifying a particular statute. Natural language. Language spoken or written every day as opposed to language that is specially designed for computer communication. Terms and connectors. Universal character. A special character, like for example asterisk, exclamation point, question mark, that can be used to represent one or more characters in a search query. Root expander. An exclamation mark that stands for one or more characters added to the root of a term you are searching in Westlaw or LexisNexis. Wild cards. Special characters like, for example, asterisk, question mark, exclamation point, that can be used to represent one or more characters in a search query. Pinpoint site. A reference to specific material within a document, like, for example, a quote, in addition to the citation of the entire document, also called a jump site.